roll, please.
Senator Anderson,
Here.
Senator Hutchings,
I'm here.
Senator Pappas,
Here.
Senator Steinmetz,
Here.
Representative Blake,
Here.
Representative Brown,
Here.
Representative Crank,
Here.
Representative McGuire,
Present.
Representative Newsom, here. Representative Obermuller,
Here.
Representative O'Hearn,
Here.
Representative Western,
Excused.
Co-Chairman Von Slater,
Here.
Co-Chairman Eklund.
Here. Okay, committee, the first thing we're going to work on is abandoned vehicles. And we have some people, statute up changes. We have some people here to testify. We moved, if you remember, we moved this from yesterday's meeting to today. So I think we'll go ahead and get into that if we could. And I guess we'll begin with, I'm looking for it again on the wrong page.
Mr. Chairman, I believe it's Brianna Smith. She's with the Wyoming Towing.
Okay, sorry, Brianna, I couldn't find my schedule here. I thought I had it laid out this morning, but apparently didn't. Go ahead when you're ready.
Thank you, Mr. Chairman. It might actually be a little bit better to start with Ms. Bruckner. We did form a committee during this last meeting with you guys, and we worked pretty closely over the last month or so with the Clerks Association and with YDOT to amend some of the abandoned vehicle statutes along with some of the lien and some of the titling statutes. Perhaps it would be best to start with Lacey for an overview of everything. She worked with the clerks much closer, and then I can explain some of our amendments. I know the clerks have some amendments they would like to discuss.
Okay, go ahead, Ms.
Mr. Chairman,
Oh, yes, co-chairman.
could we have somebody explain the bill to us, please? Like Heather? Could she
Okay.
explain the bill?
That would be fine. Heather, are you prepared to explain the bill for us?
Yes, Mr. Chairman. This, the bill that is in front of you that people will be discussing today on this topic is the 21 LSO 247. It's abandoned vehicles, towing service liens and titles. And the focus is on here in the title of the bill draft to amend procedures for abandoned vehicle liens and also amending procedures for junk vehicle titles and extending the lien enforcement authority to counties and municipalities. However, I think that might be an issue. I don't think they want to do that anymore. And then establishing limits on fees and conforming provisions. So that's, and then on page 1, we're starting to describe the affected sections of the law. Moving to page 2, we're in Title 29, and Title 29 is the liens title. Frequently, this committee operates in Title 31, which we will get to, but first we're going to be in the liens title. And it goes into 29-7-101 for regarding the persons entitled to a lien and exception. And this section of 29-7, that whole section of the law is our liens on personal property. And this section describes basically a warehouse lien. And this, the added language specifies that a towing and recovery service as defined in the titles that we'll get to over in the vehicle titles is not a warehouse under the UCC. That's what 34.1-7-102A 13 and is entitled to a lien under this section. So it's clarifying that if it does get a lien, if a towing and recovery service gets a lien or is entitled to a lien, it doesn't go to the UCC to be a warehouse. It comes here to be a mechanic's lien. Using these titles, not the UCC. That's what that section is. And then 29-7-102, this section is this tells the process for how a towing service will do that. So if a vehicle is subject to a lien under this title, the way that a person will process that lien is laid out all on page 3. Within 30 days, they need to do certain things. They need to, give certain notice. And it tells that the information that's provided, the information that's required, and then the first subparagraphs A and B are information that would be required in notice anyway, but then it adds a subparagraph C just to specify this is a vehicle. So you need to also include the make, the year, the model, the license plate number, and state indicator if that's available, and the VIN. And then it also adds a limit in this section to the duration of collectible storage fees shall not exceed 180 days from the date service was completed. And that's consistent with some other timing in these lien statutes as far as 180 days for other types of personal property. And so the lien, that just sets the limit. And then finally, number 3 is just to specify the vehicle as a broad definition in these in that lien statute. Next, on page 4, we're moving over to the Title 31, which is the motor vehicle titles, and 31.2 is the Title 31, Chapter 2 is the title and registration section of the titles. And so this is going in and to describe that the titles need to, the substance really changes on page 5 to specify that an owner or agent of an establishment for towing can obtain a title following this process that's laid out right here, because they were running into issues with being able to obtain titles. And so this is saying that if it is a vehicle that is has a value of $2,000 or less, then they need to provide notice to the notice as is required to owners and lien holders, and then within 30 days of that notice, they can claim it and obtain a junk title. And there is one thing I wanted to alert you to at the bottom of page 4, just to go back one. Throughout the abandoned vehicle statutes, most of the time the term retail value was used. So where this bill touched statutes that mentioned some other type of value to make it consistent, because more frequently it said retail value, to make it consistent, I had turned it, made everything be retail value. I believe, just as a precursor to what you're about to hear from folks, they want the consistency to go the other way. So they're going to recommend a whole bunch of statutes to change it from retail back to fair market value. I don't have a dog in that fight. I don't care which way you go. This was simply at the bottom of page 4 and other places where you see retail value. That was to make it more consistent with what already existed more frequently. Okay, so that was the process to obtain a title on page 5. Now, then at the bottom of page 5, we start to get into Title 31, Chapter 13, and that Chapter 13 is the abandoned vehicles title of this section. So this, starting on page 6, it is, well, again, the bill currently, it was just specifying, my understanding from several discussions was that that sometimes it's not an officer, but it's someone in the county who requests that a vehicle be removed. But I think, again, a precursor to what you might be hearing today is I guess they don't want to allow a county or municipality to do that anymore. So some of this, I think they're going to be asking to come out.
Mr.
And that's, I
Chairman,
guess,
Yes, go ahead.
Mr.
Senator
Chairman,
Anderson.
I have a question on that. It says police officer, and we're careful to add county and municipality, but a lot of those vehicles are on the highways, on the state highways, and it's a state trooper that actually puts a notice on the vehicle. Are they going to correct that too, Heather?
Mr. Chairman, Senator Anderson, I think that their intent is going to be that, for example, this whole section would just go away because then it wouldn't need the change. Because if they're not wanting to add county or municipality, then it would just be as is, which is saying that if a vehicle is removed at the request of a police officer, or they may have decided, and I'm sorry for the uncertainty, I don't know, they had some changes later, but they may be wanting to change that to at the request of a peace officer. But I mean, it already says at the request of a police officer, and so they're following the process of an officer, as you pointed out, tagging a vehicle on a county road or a state road or whatever. So I think that this whole section might just go away. And then, and looking at the bottom of page 6, again, it looks like they will probably want that one to remain fair market value. So this part would go out of the bill as well. So let's flip over to page 7. And I'm guessing, again, this was to extend that power because like a county may say, please come remove this vehicle. But I think that they're now not wanting to. But I think this section will remain in here because if you notice at the bottom of page 7 on line 23, there is a retail value that I'm guessing that they're probably going to be wanting to change that to fair market value. And so then we flip over to page 8, and at line 6 is another retail value that an existing retail value that I think may be being changed as they go through. The bottom of page 8, that was an extension to the who could call to remove a vehicle and have it be considered abandoned. And so that would probably be going away. And so now over on page 9, this was another consistency thing. Elsewhere in the lien and abandoned vehicle statutes, it just specifies that when a notice to someone that their vehicle may be subject to a lien or to a lien sale, it just had the return receipt requested. And so this was a consistency thing that you see there on lines 9 and 10. And bottom of page 9, we are then moving into title 30 or to 31-13-105, which is it was another section as you flip over to page 10 that was specifying that this could be a vehicle that the county or municipality asked to be removed, but I think that will probably be going away. Same with bottom of page 10, that was doing that. Same with page 11, I think. And if I'm wrong and if they don't want to be extending this to the counties, then all of these will remain. And what is happening on each of these pages, Mr. Chairman, is that it's just simply extending it to extending the idea of that it could have been a county or municipality and not an officer who requested the vehicle was removed, if I'm wrong, but they'll get into that, I believe. So now let's see, moving over to the bottom of page 11 is 31-13-109. And this is the disposition of a vehicle that's been left unattended. And specifying that a vehicle that has been, so this is a vehicle that's been abandoned or, left as abandoned. It is in subsection A on page 12, it's removing this time period but not entirely. It's just putting it into a place that makes more sense, which I'll call out as we get to it. So in subsection B, this is saying after the time period provided in subsection A or in G, which is where the time period has been improved to make more sense for the towing service, then the owner can begin this process to dispose of something. Page 13 is just making things consistent about the state indicator, because sometimes it's not always available. And then the certified mail return receipt requested. And then finally coming to page 14, it is the subsection G, which is really fixing that at any time before a sale under this section, the owner or lien holder of record may reclaim the vehicle upon payment of expenses. That can always happen. And then there's a stricken section. Then it goes to the duration of collectible storage fees shall not exceed the 180 days, which is what had been the case. And I promised you a time frame or where that 30 days moved to. And I think I must have skipped over it. Oh, I beg your pardon. I told you that 30 days moved, but really that was one of the things that was causing the problem. Is there was back on page 12, that 30-day period, it was conflicting with the lien statutes back in the Title 29 when a towing service needs to go over to do a mechanics lien. And there were timeframes in there that 30-day time frame, and they were conflicting with one another. So it was removing that. That's where that came from. And then the bottom of 31-13-112, this section I anticipate will go away because that was what was extending it to the county or municipality. So that about the bill before you, but now I think it might be good to move to Lacey Bruckner, because she's going to fill in some of these holes of my uncertainty of wondering, of thinking that they are making some changes.
Mr. Chairman.
Yeah, Representative Blake.
Thank you, Mr. Chairman. Heather, on page 14.
Yes, Mr. Chairman, Representative Blake.
So right now it's $20 a day and shall not exceed $760. Is that the way it's currently in statute?
Mr. Chairman, Representative Blake, yes, it is, because the counties and counties, they have an abandoned vehicle fund from which these are paid. And so that amount of the $750 or $20 a day is actually that was already mentioned in the vehicle that a county would be responsible for. The reason this one is changed is that this is talking about a private vehicle. This particular section is talking about a private vehicle, and so it's one that's not going to be paid by the county or municipality from that fund. Instead, it starts using this 180-day duration and that cost limit, because that's what's on other liens as a limit for to be able to collect that amount of time, or that fees for that amount of time.
A follow-up, Mr. Chairman.
Go ahead.
So my car breaks down on the interstate, it gets towed away or whatever happens. We're not going to have any set amount that a facility can charge per day up to 180 days. It would just be whatever they decide that price will be.
Mr. Chairman, Representative Blake, the distinction that's currently made in the abandoned vehicle statutes is where the property is abandoned, whether it's abandoned on private property or public property. And so Yes, there's a limit if you just if you abandoned it on public property. If you abandoned it on private property, there's also a limit, but it's just the lien limit at that point. Because, for example, I towed your vehicle from private property to my tow place, and then you just don't pick it up. It's on my private property, and so now I have a like a mechanic's lien, or I might be saying that wrong, storage lien, for so I can collect it based on what the lien statutes would already allow me to, instead of some additional amount layered on top, or not additional, but some other limit layered on top of that.
Okay, thank you. I was just a little concerned about that section right there. Thank you.
Okay, any other questions by the committee? Excuse me. So one of the questions I'm going to have to start with, and we'll start with Mrs. Bruckner. Explain to us the mechanic's lien, the difference between that and a storage or tower's lien, or what distinguishes those two, because I'm not sure I understand that.
Okay, Mr. Chairman, Lacey Bruckner, YDOT Compliance and Investigation. A storage lien is a situation where a towing company or a storage yard has a contract with someone to tow their vehicle and store it for a given period of time. And there's a specific contract between the owner of the vehicle and the towing company. And then for whatever reason, the owner of the vehicle chooses not to retain the vehicle and pay the towing company for the services that they provided. So in that circumstance, there's a contract that I guess has been breached, for lack of a better term, and therefore that situation would fall under the storage lien process under Title 29, so that the towing company can take procedures to do a lien sale, sell the vehicle currently at fair market value, and then make up some of their costs that they incurred through towing it and storing it. An abandoned vehicle is a situation where, like Representative Blake identified, where you leave your vehicle on the highway, that's abandoned on public property, and that is going to be impounded by a law enforcement officer. But if I have a towing yard and someone just leaves their vehicle on my property in the night or something, and I don't have a contract with a particular person, the owner of the vehicle, for example, then that's a truly abandoned vehicle. And that situation is going to lend itself to the processes that are laid out in Title 31, Chapter 13, under the abandoned vehicle process. And that is kind of an issue that was causing confusion for the clerk's offices in some cases, the department's instructions to our licensed towing and storage yards on how to proceed. The language that was stricken on page 14 of the bill, excuse me, that is where the confusion was lying at whether do we go through the abandoned process or do we go through the storage lien process, because this language that starts on line 5 on page 14 and goes through line 11 is a circumstance where there was a contract with the owner of the vehicle to tow it or repair it or store it, and that owner chose not to follow through with their end of that contract, if that makes sense, Mr. Chairman.
But that constitutes the mechanic lien.
Correct.
The abandoned vehicle. All right. Okay, that's what I needed to know. Thank you. Any other questions on that part? Then we'll.
Mr. Chairman, if I may just make a little bit of a clarification on some of that.
Okay. Go ahead.
So, yes, so I think, just to clarify a little bit with how this came about as well, and I hesitate to use the word contract under the storage or mechanic liens, and in certain ways, because it also encompasses tows that we do for the highway patrol, or if we have a contract to go out and recover wrecks and things like that. These also fall under the mechanics and storage liens. So in my reading of the mechanics and storage lien, it really is anytime you confer a benefit on somebody else's property. And I think for us as a towing industry, the distinction that we wanted to make and have iterated in the statutes is really the difference between a storage lien or a mechanics lien and an abandoned vehicle is whether or not you can identify a possessory interest in that vehicle. If we can identify someone, whether it's an insurance company or a bank or a lender or a private party who has a possessory interest in a vehicle, the goal for the towing companies in changing these statutes was to be able to identify those people as soon as possible. We want to be able to, as soon as we bring a wreck in, whether it's from the highway patrol or a municipality, be able to identify a possessory interest and let those people know that we have their vehicles. The distinction with the abandoned vehicles is, and where we're running into the language, I believe, with the municipality part, is that what we wanted to identify was that the abandoned vehicle is a vehicle where law enforcement has already attempted to track down a possessory interest. They couldn't track down a possessory interest, and that's identified by them leaving the green sticker on the vehicles. So an abandoned vehicle is a stickered vehicle by law enforcement where there has already been an attempt to track down a possessory interest and one cannot be found. Those trigger access to the abandoned vehicle funds that the counties have just to help keep the counties cleaned up. That's different, again, from somebody that abandons a vehicle on private property. What we were having issues with is towers and private property owners, for example, owners of apartment complexes where you have college students abandoning vehicles regularly, trying to access those county funds to pay for those removals from private property. And that's not what the fund was intended for. So those are the three distinctions we were trying to really clarify, that if we've conferred a benefit and we can find a possessory interest right away, it goes under the storage lien statutes, where we then have 180 days to work with those people on billing and getting their cars back. If law enforcement finds it out on a highway or an interstate and they have tagged it because we can't find a possessory interest, then we have access to those county funds to help us clean it up. If it's abandoned on a private property, that contract becomes between the towing company and the private property owner. And those abandoned vehicle county funds are not used at that point to help tow that vehicle.
Okay, questions from the committee? Yes, Senator Anderson? Jim, can you hear me? Senator Anderson, go ahead.
Yes, thank you. Thank you. I think, Mr. Chairman, I think I heard that if there wasn't, if it was private property, the county wouldn't put up the money for the towing and storage. And so the private property guy has to deal with, or has to pay the towing company for towing off of his private property. Is that correct?
Yes,
Yes.
that would be correct in our estimation. I mean, traditionally, that's a contract between the private property owner and the towing company. They have other avenues, I believe, to help compensate them for those tows. They can take it out, for example, if you're in an apartment complex, you hold back deposits, you do things like this. I don't believe that the county fund was intended to clean up private property. I think the county fund was intended to clean up counties and the public properties of the counties.
Mr. Chairman, that towing fee could be considerable in my experience. And I could see a private property apartment owner just pulling those vehicles over on the street or onto somebody else's property. Does that happen?
Go ahead, Mrs. Smith.
I suppose it could. I mean, we're coming into certainly some issues, especially in Cheyenne. Part of our other amendments will address expanding this fund in some ways actually to accommodate motorhomes and things like that that are starting to be abandoned quite frequently on public property, bigger vehicles that people are living in. I suppose it's a scenario that could happen. You still have to have the law enforcement officer come and research it and do the investigation and tag it. So I suppose at that point, it may be in the discretion of the law enforcement officer to determine how it got there. But in my experience, that's not a common scenario. And I guess I should add also that I think as the statutes read, if you are a private property owner, you also have the ability to do the abandoned vehicle process and auction and title that vehicle and sell it yourself as a private property owner for the profit of the vehicle.
Mr. Chairman.
Yes, go ahead, Senator Hutchings.
Thank you, sir. Ma'am, Mrs. Smith, I believe it is. Can you tell us exactly what this bill is doing for you or against you? What do you like about the bill?
Well, I think what it's doing is clarifying a lot of information. I think that the difficult situation with towing companies and contracts with municipalities for the removal of vehicles, whether it's abandoned or in an accident on the highway or interstate, was that we had essentially 3 different sets of lien statutes that controlled. We had the abandoned vehicle statutes, we have the storage lien statutes, and some of the confusion was that in that storage lien statute, originally they allowed for 2 different processes for lien sales and for notice of possessory interests in those vehicles. Part of those statutes borrowed from the warehouseman lien statute. And what we were running into was attorneys and other people construing that as, well, then you must also be warehousemen. So there was a lot of confusion with which set of statutes and what kind of lien controlled in what kind of situation. The other thing that we were running into that I think that we discovered through this committee is that the abandoned vehicle statutes kind of construed things, they kind of made notice of possessory interests, notice to lien holders, notice to banks or insurance companies, synonymous with the abandoned vehicle sales, so that we as towers were not able to get the information we needed to contact the lien holders until we were ready to sell that vehicle. What these statutes do, I think, is clarify when each set of liens controls. The abandoned vehicle statute should really only control if it's genuinely an abandoned vehicle. And my definition of that is we cannot find a possessory interest. The storage lien statutes should control if we can find a possessory interest, and we need then to be able to find that possessory interest as soon as possible. And that's why we've built in that towers have to go through the process and track down all of the possessory interests within 30 days of bringing the vehicle back into their yard. And then we kind of eliminated the section that let people kind of flow over into the warehouseman's lien. So what we identified in the possessory lien statutes or the storage lien statutes was that lien sale process would control. We would not use, this is kind of confusing, but originally in those lien statutes, it says you can use the lien sale process that belongs to the statute, or you can also jump over to the warehouseman's statutes and use that lien sale process. So it had 2 different lien sale processes under one lien. And that was creating confusion. And what this language does is say, we're going to use the lien sale process that goes with the storage lien. We are not going to use the lien sale process that goes with the warehouseman's lien.
Gotcha. a good job of clarifying that. Now, do you have angst against retail over fair value, or does it matter to you?
I think we're the ones, I think, again, there's some statutes that it makes sense to expand a definition. We have also put that in our proposed amendments. For the abandoned vehicles and for the store or salvage lien statutes, when you're talking about junk titles, when you're talking about abandoned vehicles, traditionally, these are vehicles that have been abandoned because they don't have any value. Or you have vehicles that you acquire that have been, totaled and wrecked to the point where they don't have any value. For those statutes, it does not make sense to use retail value, because retail value could be a blue book value. It could be an original value. We want the fair market value language in there because we want somebody, an independent dealer, to come and say, yes, this vehicle is in fact worth less than $2,000. The importance of that for towers is that when we then title that and salvage it, we're getting, on good days, $50 or so a pound for salvage. So when you're looking at a vehicle, you're maybe looking at $100 or $150 in salvage for that. So we were trying to avoid having values that were really, retail values, which could be very high. The other statutes later on under titling, the salvage statutes that control the salvage titling use a different definition, which is retail value. And that's important because insurance companies total out vehicles based on the percentage of damage of the retail value. So if you have 50 or 75% damage of the retail value, then an insurance company will total that vehicle out, and then the tower is required to go and get a salvage title. So I think what needs to happen, in my opinion, is that throughout the statutes, we need to change things to market value, fair market value, because the abandoned vehicles and the salvage vehicles need to be based on fair market value. The two statutes that define, salvage or as 75% of the retail value, we just need to expand that definition to say, or $2,000 or less. We can have more than one definition of salvage, but there's two different scenarios when you're going to be going and getting a title.
Thank you, Mr. Chairman. Thank you, Mrs. Smith. That was a great job.
Yes, thank you.
So this has been corrected on page 6. I don't know what that is, Romanet XI, junk vehicle, and it has a retail value. It's taken out fair market value language, put in a retail value of less than $2,000. Do you believe that corrects the problem you were just speaking of? Page 6, the
Yes.
bottom.
So the language we originally had in there on line 21 read, which has a fair market value, and then that was changed to that has a retail value, but we believe that should read fair market value and not retail value. The goal of this was to have towing companies have to verify in some way that the vehicles really are not worth anything. So again, I think the fair market value and having the requirement that somebody come and verify that it is actually junk or totaled is a better way to go than retail value, because I think that would be construed later on as something as easy as a blue book value.
Okay, so that's a correction we'll need to make, an amendment to make on this bill to clean it up the way that the towers would like to have it. Yes, Chairman Von Flateren, go ahead.
Could we have Ms. Smith go through each part that she would like to change, fair market value, county or municipal, those kind of things? Could we have her do that, please? Or have Lacey Bruckner do that?
Yeah, whichever of you would like to do that. Could you do that now, and we'll see if we can make sure this is fairly clean?
Yes, Mr. Chairman. We can go through it if it's okay with Ms. Smith, and wherever there are sections that the towing companies want to change to this draft, if Ms. Smith could maybe just mention that at that time, is that reasonable?
Yes.
Okay.
Just go ahead and continue on, Ms. Bruckner, and Ms. Smith, you go ahead and interject when you need to. Go ahead through the bill, please.
Great. Thank you, Mr. Chairman. So briefly, Ms. Smith and I compiled a working group for this. We had towing companies represented, county clerks represented, a few insurance industry representatives, and we did consult with law enforcement on this to try to encompass all the concerns or views that there may be. So hopefully we have a draft here that takes into consideration every angle of what might occur with abandoned vehicles and storage liens. So to start with, I guess, on page 2, 29.7.101, this was added to clarify that towing and recovery service is not a warehouseman, and that those situations where the towing companies are entitled to a lien for a vehicle through storage should not be directed over to the sale process under the warehouseman's lien statute in 34.1. That just specifies that for clarification. On line 18, 29-7-102, in this section where it talks about the right of possession by a lien claimant and removal of the property, since the group felt that it would be better to keep these vehicles with towing companies under Title 29, the group felt it was important to specify what information is required for a notice on a lien sale, because those steps were specified in Title 34.1, but they weren't specified in Title 29. So we felt that it was important to make sure it's clear what's expected in the notifications, and also that it's clear that there's that 30-day time frame so that these don't sit and accrue storage fees and other expenses indefinitely. On page 3.
May I interfere just a minute here, Mrs. Bruckner? What happens in a case you've gone past the 30 days? We're changing the law here, and I know that we've got this going on. We have people with a 50-acre lot that's loaded up with cars that they can't get rid of. And they've gone well past the 30 days. Some of the cars may have been there years. Is there a mechanism for them to get rid of those cars, or does it become retroactive with this bill? In 30 days they can fix their problem?
Mr. Chairman, I believe that if you have that situation now where you have several vehicles on a yard that have been there for years, that you still have the opportunity to dispose of those. This 30 days is kind of a protection for any person out there with a possessory interest, as Ms. Smith referred to earlier, so that they're getting notice quickly to have the opportunity to come pay for the services and reclaim the vehicle. And that way they're getting notice right away, which our insurance industry representatives in our group appreciated that. They felt that the sooner they were notified, the better, as I'm sure lien holders would be appreciative of. So if this 30 days, if the company didn't send the notices within the 30-day period that's set here now, they could still go through this process, I guess. I think this would create maybe an opportunity for someone who had a right to the vehicle that had not been notified to come back, maybe through a civil action of some type, and address that in relation to the fees that were being charged for the tow, or possibly the proceeds from a sale under this lien sale statute.
Okay. Well, go ahead.
Okay.
Oh, Ms. Smith,
Yes.
go ahead.
I'll just interject my position on that as well. I think there's actually two mechanisms for people who have vehicles currently on their property to get rid of them. And I think that, again, this is just training with the towing companies and kind of a misunderstanding of what a lien actually is. So I think the first mechanism is actually if you've got vehicles that have been there for a number of years, the junk title process, because those requirements are not in the junk title process. So if I had a vehicle on my property that was very old, I would probably utilize that process if it didn't have any value. I think the important thing to remember also is that the storage lien statutes, so they still have a lien on vehicles that may be there a year later. I think the confusion is that these statutes are designed to give us priority in liens. So our liens don't go away just because the vehicles have been there a long time. We just lose our priority compared to a bank or some other person that has interest. So you can still use, if you have a vehicle that doesn't have any value, the junk title statute to get rid of that, or you can use your storage lien statute. I think the 30 days in this particular area was to encourage towing companies to attempt to find possessory interests as soon as possible. What we were running into with YDOT that was just a miscommunication in some places was that the towers were not allowed to submit a lien search or a title search to YDOT for at least 30 days. And what we wanted was the towers to be able to submit that right out of the gate to find people who might have an interest and want to get that vehicle back. So this is really to encourage towers to find possessory interests as soon as they can.
Thank you. Any other questions while we're here? Ms. Representative Newsom, you had a question earlier and I didn't ignore you. We kind of moved on. Did you have something you wanted to ask?
Thank you, Mr. Chairman. No, my question got answered through the course of this discussion. Thank you.
Okay, thank you, Representative. Okay, ladies, continue on.
Okay, thank you, Mr. Chairman. And I would just like to mention really quick here, the situation that Ms. Smith was talking about where YDOT wasn't accepting or processing the title searches for at least 30 days was under statute in Title 31, Chapter 13, abandoned vehicles. And that situation has been corrected through our Motor Vehicle Services Department without any change required here, although we do have some clarification to that later on in the bill.
Okay.
Okay, thank you. So I guess we're on page 3, and this just sets out the specific information that has to be included in a notice on a vehicle that's subject to a lien under the storage lien statutes. And just on line 19 of page 3, limits the duration of the storage fees to 180 days. We felt that that was a reasonable length of time to be able to find a person with a possessory interest. And if they were not, chose not to claim the vehicle and pay for the fees, then that gives the towing and recovery service the opportunity to follow through with the lien process and dispose of the vehicle through a lien sale. And doesn't let those storage fees accrue for years, year and a half, 2 years, or what have you, which is a protection for anyone with an ownership interest in the vehicle. And then on page 4, line 2, that just specifies the definition of a vehicle, since in 3113, since we're adding some specific notifications and information to Title 29 for vehicles that are towed. And then moving down on page 4 to line 20, as Ms. Jarvis had indicated earlier, and Ms. Smith spoke to, originally the statutes addressed this as a fair market value. It was changed to retail, but I would concur with Ms. Smith that when we're dealing with abandoned vehicles and junk vehicles and those that have been wrecked or damaged to the point where they don't have any retail value other than scrap, that it is appropriate here to use fair market value for the vehicle itself rather than retail value, which would be what a dealer could sell it for. And you would go onto an Edmunds or a Kelly Blue Book or an NADA and you would type in the year, make, and model, and it would just give you an average retail value versus what that specific vehicle's market value is based on its current condition.
Okay, so that is a change, one of the changes we'll make.
Okay. And moving on to page 5, this section here addresses the junk titles that were added to statutes in 2016 to allow storage companies, towing companies to dispose of vehicles that were abandoned and worth less than $2,000 to be able to dispose of those in a manner that's less expensive. By the time they put the advertisements in the paper for the sale, that can get costly and turn out to cost them more than what the vehicle's even worth, and it's difficult likely to dispose of those at an abandoned vehicle sale. So this section 31.2.111 for the junk title was already in place for abandoned vehicles, and the group felt for consistency it would be good to have vehicles that were towed and being stored under the storage lien statutes that were worth less than $2,000 to also be able to dispose of through this junk title process. Because there again, if it's a circumstance where they have found someone with a possessory interest, but that person chooses not to reclaim the vehicle and it's worth less than $2,000, the costs of going through the sale process and the advertising process is going to turn out to be much higher than what the towing company would be able to recover through a storage lien sale. So that's why the group felt it would be a good change to allow vehicles under the storage lien process to also obtain a junk title when they have been towed by a towing and recovery service.
Okay, so
Does anyone have questions?
that section is the way you would like for it to be then, correct?
I believe so, based on our discussions from the group, but I would ask Ms. Smith to mention anything if the towing association has difference.
Yes, we don't have any objection to it, the way anything reads on page 5 through those amendments. Heather's got something.
Okay, Heather, go ahead.
Mr. Chairman, I believe, and the proposed amendments that both folks submitted this morning, last night and this morning, they do describe each of these places where there's retail and fair market value. And I think, should the committee wish, we certainly can find all of these, LSO can certainly find them all. And I just wanted to say there's one that's not on their lists, but with the free reign of the committee, I could certainly find them all. For example, on page 5, line 5, I believe probably they would want that to be fair market value.
Yeah.
And so the combination of the proposed amendments that they submitted and which called out these fair market value retail value things, as well as a search on our own. I think we could address the changes on for the value language.
Okay. Are you ladies okay with that? With the our LSO staff finding these fair market value portions of it and correcting it rather than going, I think we're trying to expedite our bill and get through this quicker. Am I correct, Heather?
Mr. Chairman, I just, I had noticed that the one on page 5 wasn't on their list. So I was just simply saying, whenever we decide to do whatever their changes are proposed, if the committee wants the retail versus, sorry, if the committee wants fair market versus retail, that if you could give LSO the rein to just make sure that we catch them everywhere, whether they're on their list or not. Expediting, that would expedite things as well. It's true.
Okay, does that sound okay?
I agree that that would be an
All right.
efficient way to go.
Yes,
All right.
Mr. Chairman.
Okay, thank you. I guess we will proceed on and see if there are other changes we may need to make.
Okay,
Oh,
thank
we
you.
do
On page 6, the information that Ms. Jarvis mentioned on line 7, where it was added county or municipality. I believe that the County Clerks Association wishes to address that, where they voiced concern that the terms county or municipality were too vague, and they would prefer that read law enforcement officer or peace officer. So I don't know if there is someone with the County Clerks Association on now that would like to address that while we're here.
Mr.
Mary,
Chairman,
Go ahead.
Mr. Chairman, I believe Mary Langford is on the, she's with the County Clerks Association of Wyoming, and I believe she has Misty Tinney with the Laramie County Clerk's Office as well, and I think she's on the phone.
Okay, welcome to our committee, ladies. Go ahead when you're ready. Give us your input.
Good morning, Mr. Chairman. I'm Mary Langford, and I have the honor of representing the county clerks today. Just as a point of interest, county clerks are meeting with their commissioners on the first Tuesday of every month. That's why I'm here and they're not. So I really appreciate the opportunity to represent them today. We proposed, or we, the clerks, proposed one small amendment concerning a police officer, and it is in several places throughout this law or throughout this proposed legislation. We have some concern about it being the addition of county and municipality, because that seems vague. And that vagueness brings to mind, who is that? Is that a mayor? Is it a county commissioner? Is it a county clerk? Who is that county or municipality representative that's going to be able to get involved in this, where we feel that it should be a law enforcement officer? Then with that language, this bill has worked fine with police officer in place. We also don't know if maybe peace officer would be a better option, or a law enforcement officer, but I think the Clerks Association would prefer that it stay as a law enforcement person, as opposed to expanding it and making the law a little more vague. And it's as simple as that.
Okay, so we would remove in place of police officer, just put law enforcement officer, and that would be all that would be there, and county and municipality would be removed. Is that what you want?
Mr. Chairman, that's correct, please.
All righty, thank you.
Mr. Chairman, I believe that Ms. Jarvis has been trying to get your attention.
Oh, I'm sorry. Go ahead, Heather, go ahead. Thank you, Don.
Mr. Chairman, it may be, it's the committee's preference, it may be that police officer is fine, and then this statute would be just, this particular section would be completely unaffected. However, if the committee chooses to change it, it does appear as though both law enforcement officer and peace officer are used. The more general term, I think, that's more used more frequently, I've been looking throughout Title 31, may be law enforcement officer, if it even needs changed. I mean, police officer is what is there, and may not be broken, may not need fixed, depending on what the committee's preference is. If once county or municipality is removed, then this section would just remain, unaddressed. Well, I mean, unchanged.
All right. Okay. I don't see any other hands raised. So go ahead and continue on.
Thank you, Mr. Chairman. On page 6, then on line 21, that's just the same discussion with the fair market value versus retail that I think our group would prefer in Title 31, Chapter 13, remain fair market value. On page 7, the same, line 5, the same issue, changing that to law enforcement officer or leaving it. Let's see. On page 8, line 6, it looks like there's another mention of retail, which I believe was in the statute already. Oh, sorry. I believe Representative Newsom has a question.
Representative Newsom, do you have a question?
I do. Thank you so much, Mr. Chairman. I have a couple of questions on the determination of fair market value. On page 4, it says that the determination would be completed by an independent, disinterested licensed Wyoming vehicle dealer. On page 6, it says there's a determination by, I think, the police department. And on page 8, there's a determination by sheriff. So I'm wondering how that all works. And I don't believe that the police or the sheriff are maybe qualified to, or it's not their, in their wheelhouse to make determination of value of a vehicle. So if you could clarify how the value of a vehicle is going to be determined, that would be great. Thanks.
Mr. Chairman, Representative Newsom, in the situations where there's an abandoned vehicle that's been impounded by law enforcement and it was stickered abandoned, and they've had it removed from public property, or they have had it removed from the highway and impounded, this process for abandoned vehicles, the title searches and the notifications and the advertisement in the paper, that is all done through the sheriff's department in the county where the vehicle was abandoned. So for those public property vehicles that are abandoned, the sheriff's department determines the value, and they conduct the title searches through YDOT. YDOT sends notifications to the last known owner of record and any lien holder that we find. And then the sheriff's department determines if the vehicle is valued less than $2,000. And in that instance, then they can just dispose of it through a licensed storage and disposal facility. If it's worth more than that, they can do that through an abandoned vehicle sale through the county. So the sheriff's department is determining the value only on the vehicles that they're responsible for that were impounded on public property. Now, when it talks about from an independent licensed dealer evaluation, that is for a vehicle that is not impounded by law enforcement and is being or was abandoned, on private property, and the property owner or the towing and recovery service is determining the value to proceed either through an abandoned vehicle sale for private property or through the junk title process that is listed out in Title 31, Chapter 2. Does that make sense?
Yeah.
It does. Thank you.
Thank you.
Thank you.
Okay. So I'm just looking through here. We've already discussed the county or municipality language and correcting the reference to a retail value in the abandoned vehicle statutes to fair market value. So on page 9, line 9, it mentions sending certified mail, return receipt requested. This is for consistency purposes. In the lien sale statutes, it does mention a return receipt requested. And we had some concern from the representatives from the County Clerks Association that they have encountered situations where property owners who have been required to send these notices have questioned whether they're required to provide that return receipt. But since there's not really a way to determine what is actually being sent in the notice, this return receipt requested is just another step in ensuring that any person with a right of possession to the vehicle was sent a notification of where it's at and what the fees are due and when it would be sold. So that's kind of just an assurance that those interested parties are getting the notification. Okay. Okay, so moving on, page 10, it looks like we've the same discussion we've had regarding county or municipality language. Same thing with page 11. Page 12, starting at line 10. As I mentioned earlier, this language was causing some confusion because it specifically references a vehicle left at an establishment for service, repair, towing, or recovery falling under abandoned vehicle statutes, where if there has been a person with a possessory interest in a vehicle that's left at one of these businesses, then they should be able to proceed through the storage lien process clearly, not this confusion of which one do I pick, which one do I use. So that is the reason why our working group felt removing this language from this section would clarify that better. And if Ms. Smith would like to explain that further, please do.
We just have a quick clarification. I agreed with the group that this should be removed, primarily because I think it conflicts a little bit with the first sentence is the definition of abandoned vehicle. Again, we want abandoned vehicles to be defined as somebody that we can't find a possessory interest for. It's not just one that's left because somebody chose not to pay their bill. That falls under different remedies and statutes, I believe. So that was just to clarify, to kind of help clarify the abandoned vehicle definition, in my opinion.
Okay, so to kind of speed things up, we've been through most of those explanations. And what we're real curious about is what changes that substantial amendments and changes we need to make on the bill. So to kind of speed it up, if you'll just hit on those things, the parts of the bill that we believe are good, we'll just leave alone. And
Mr. Chairman.
Go ahead, Stan, Representative.
Yeah. Thank you, Mr. Chairman. I know there are other people who want to speak on these proposed amendments. I don't know if we should move the bill, then work on the amendments, or just keep going as we are. But I know there are other people who wish to speak on these proposed amendments.
All right, we'll get them into the conversation before we're done, but we'll have these ladies work with other changes that we might need to do in the bill. Co-Chairman Von Flatern, did you have something to say? Your hand was raised, I thought. Maybe not. Okay.
Mr. Chairman.
Yes.
Okay.
Mrs. Smith, go ahead.
I'll just be brief. We have one, I think what would be a significant change for you guys to consider that kind of was a little bit lost in transition and didn't show up in the bill. If you look at page 14, this is under Wyoming statute 3113-109. The language regarding the limit on the fees, the $20 per day and the $760 max. Again, this is the funds that the counties have that they draw from titling fees and such to pay towing companies. We omitted it from that section because, again, this was kind of under the private property section. And it also existed, which hasn't been put in the bill, but we omitted it there because it also existed already in 31-13-111. And that's the section that kind of defines the process for when a vehicle has been tagged by law enforcement and really triggers access to that fund. The Towing Association does have two amendments to that section because it no longer controls in the other section that we would like to address. We did submit them online to the website. I don't know if you want me to iterate them real quick or if you guys want to have later discussion about that. But we would like to amend 3113-111. It would be G2A. Originally, the rates that towing companies were allowed to charge for small vehicles that were being removed, tagged as abandoned, was $100. We would like to increase that to $125. We would also like to expand that section to define and include oversized vehicles such as motorhomes, camp trailers, trucks, or anything weighing over 10,000 pounds or 20 feet in length, and allow towers to access the abandoned vehicle fund at the rate of $225 or $150 per hour on those tows. Because what we're running into is many of the vehicles, especially in the Cheyenne area, interestingly right now, are abandoned motorhomes that people have lived in. So I don't know the best way to address that change because it was omitted in one area, but the area that it remained in wasn't addressed in the bill.
Okay, Heather, do we have that language for that change?
Mr. Chairman, we do, yes, we do have that language.
Right. We'll go through it when we do amendments.
I
We're
think the
running-
only, sorry.
Go ahead.
I think the
Go ahead.
only thing on their list that hasn't been addressed, that just was a question, is they have a number 2 that they want inserted: service, repair, or sale, but I don't know exactly where. They say in 3113-109, which covers several pages. So I think that it goes on page 14, line 5. If they could clarify that, then we would basically most likely know all of the amendments that they're proposing.
Okay.
Is that where it goes?
Let me get over there real quick here. So 31-13-109.
Page 14.
Actually, I apologize. It should be page 14. Yes. So it's page 14, and it's lines 5 through 8. So we wanted to move the section beginning at line 8 with storage expenses that shall be computed at the rate of $20. What was omitted was the middle of line 5 where it said vehicles left unattended for service and repair. So our concern was that we just wanted to make sure that towers could bill or reclaim payment for expenses incident to removal, preservation, custody, storage, service, and repair, because the service and repair portion had been left out or omitted with that sentence unintentionally, I think.
Okay, so add that cross out section on line 5 through part of 8 back in.
Right.
Oh, okay, got it.
Just, yeah. That would be the last that we had.
Okay. Well, any questions, committee? Okay, we have some people on deck that wanted to talk. I think this would be a good time for them to go ahead and be brought into the conversation.
Mr. Chairman, I believe Catherine Wilkinson is available.
Welcome, Catherine.
Good morning, Mr. Chairman, members of the committee. It's nice to see you all virtually. My name is Catherine Wilkinson. I'm here today representing American Property Casualty Insurance Association. Mr. Chairman, we did have a few brief comments on the bill. We don't have any issue with the section that will be providing more notice to the insurance company. However, we do have some issues with some of the timeframes that are outlined in this bill, specifically to get a junk title within the 30 days. There is some concern there that should there be any type of a dispute, that the 30 days may not quite be long enough for that. And then on the opposing side, with the storage fees on the days that could last up to 180 days without a cap on the fee, that could result in a bill with thousands of dollars, Mr. Chairman. So those are our two main concerns throughout this. We do not have any opinion on retail or fair market value with those changes or the municipalities. Mr. Chairman, I will keep it as brief as possible, so I would stand for any questions that you may have.
Committee questions? I have one. What would your suggested cap be?
Mr. Chairman, currently the charge is $20 per day. Now that is a very low amount of money. We would be fine if the charge was up a little bit, but there needs to be some sort of a cap in there, and perhaps a cap and a shorter day. 180 days is a very long time.
Okay. And then the 30-day period, what do you think that should be extended to?
Mr. Chairman, I think, the 30 days is all right, as long as there may be some language that is in there about if, there is a dispute, that it can be arranged for longer throughout a contract. Or another solution also with 180 days and the fees is that there can be a set agreed upon amount that can be paid rather than just a set fee that's set in the statute. So if there is a contract between companies, a lot of times there will be a set agreement amount. And in that case, we would prefer that would be the governing document.
Okay, Mrs. Smith, go ahead.
Yeah, so I'll just kind of elaborate. First of all, I guess my understanding of the junk vehicle statute is not the 30 days. I think it's important, again, to recognize what set of statutes controls when. And when we're dealing with abandoned vehicles under the abandoned vehicle statute, when you have a sheriff or law enforcement officer who has gone out into the county or out into public property and attempted to track down an owner, identify the vehicle and that there is not an owner, and they have tagged that and then called a towing company to come back and get that vehicle, that is what triggers the $760 limit and the $20 a day in storage. That is so that fund, those rates are there so that fund does not get depleted too quickly. That is different than somebody who is going out and performing service on a vehicle where we can identify a possessory interest and we can contact that possessory interest right away. Those vehicles fall under the storage lien statutes. The 180 days is already in the storage lien statutes. That's already the deadline that everybody who, I don't care if you're a mechanic or a tower or anybody, the 180-day deadline is the deadline that has always been laid out in those statutes. So what we're saying is that the reason you have the cutoff of the 180 days is because at some point you have to foreclose on your lien. You have to foreclose on it by going to court, or you have to foreclose on it by doing a lien sale, or then you have to switch it over and file a lien. The statutes have identified forever that mark is 180 days. I think the presumption with towing companies is that they are intentionally charging storage. And I would like to dismiss that myth right now. The reality with towing companies and storage is something we we don't like to deal with, we don't like to collect on it. It's impossible to collect on. It's always an argument. So what we wanted and what we advocated for as an association is to change the laws so that we could track down the possessory lien interests like from day one. So we could get a hold of the people who have interests. If there is conflicts in the billing, if there's negotiation in the billing, that is handled with the people who are doing the billing between the towing companies and the insurance companies or the trucking companies or the persons. I don't think it has any bearing on the 180-day limit. That just says, that's just always been in there, that says you have until this 180 days to foreclose on your lien. You only have that window of time. I don't think that that should be synonymous with what people can charge for storage.
Okay. Mrs. Wilkinson, would you be okay with us leaving it the way it is then?
Mr. Chairman, thank you. I would just point out that on page 3, line 19, it says the duration of collectible storage fees shall not exceed 180 days. So that is specific to the fees and not necessarily the amount of time to foreclose on the lien.
Well, but you have to, when you foreclose on a lien, you have to have a finite number for that foreclosure. What it's saying is once you attempt to foreclose on a lien, whether it's through a lien sale or through judgment, you have to stop accruing. You have to have a finite number to foreclose on. That's always been my reading of the statutes. Again, regardless of the service, whether it's a tow company or a mechanic, it's saying that your bill has to stop at some point and you have to identify a finite number to foreclose on. And what we're saying here is that can't go past 180 days. If you want to construe it a different way, you could say, I can charge for 600 days of storage. All the lien statutes say, technically, is that I lose my priority in the lien past 180 days. This is actually imposing a limitation on towers that hasn't been there before for storage.
Okay. Any questions? All right. Are there any other people that need to speak, Mary Beth?
Mr. Chairman, there is no one else from the public that desires to speak to this issue.
Okay, committee, what's your pleasure?
Move the bill.
Moved by Blake. Second?
You have a second, Co-Chairman Von Blader.
Okay, got it. Bill's been moved and seconded. Committee, we have some amendments to make. Does anybody want to start?
Mr.
Page, go ahead. Go ahead.
I would allow LSO to strike retail and put fair market back in where it needs to be. That's my amendment.
Okay. Any discussion on the amendment? All those in favor?
I second it.
Oh, I'm sorry. Yes, thank you, Senator. For second. Okay. Ready to vote? Raise your hands if you're in favor of that amendment.
I'm raising my hand. I tried to get a fake hand up there. It won't work.
1, 2, 5, 6. So I have 6. What do you have, Mary Beth?
I have 11, Mr. Chairman.
All right, I figured I wouldn't have everybody's picture there. Okay, that amendment passes. More amendments. We have
Mr. Chairman?
Yes.
Yeah, Senator Von Flater.
Oh, so my amendment was to strike county or municipality and put in, just leave it, request of a police officer, just leave that and strike county or municipality all the way through the bill.
Second.
Second.
Third, fourth.
Seconded by Blake. Discussion on that.
Question.
Question's been called for. All those in favor, raise your hand.
Raising my hand.
I don't have all of them, Mary Beth. Tell me how many you got. I've got 7.
I have 10, Mr. Chairman.
All right. Those opposed? I think we got it to pass. All right. That amendment passes. Any other amendments?
Mr. Chairman, your co-chairman Von Fillydern has his hand up.
Go ahead, co-chairman.
Okay, so on line 5 through 8 on page 14, I would reinstate that language. If a vehicle is left unattended or unrelated claimed at an establishment for service, repair, towing, recovery, or maintenance, the cost of the service. I would reinstate that language on lines 5 through 8 on page 14.
Okay. Everybody get that? It's been seconded. I'm not sure who seconded.
Pick me.
Senator Anderson.
Okay, Senator Anderson. Any discussion on that amendment? All those in favor, raise your hand.
I'm raising my hand.
All right, I'm not getting all of them. How many do you have? I have 7 again, Mary Beth. You probably got more.
Mr. Chairman, I have 11.
11. All right, that amendment passes as well. Are we finished with amendments?
Yes, Mr. Chairman.
Are we ready to vote on the bill? Oh, Sandy, did you have a question? I mean, sorry, Representative Newsom. It might be a delayed vote.
Mr. Chairman, it looks as though Representative Obermuller has a question.
Oh, yes. Go ahead, Representative Obermuller.
Thank you, Mr. Chairman. I guess I have a confession to make about this bill. It came to us in the September meeting. It was one of the last, maybe the last item. There were 21 pages of very specific information regarding this topic, single spaced. There's just a lot to this that frankly, I at this point have not absorbed everything that's involved with this bill. Then this time the bill itself comes to us, and I just can't work back between the bill. And I tried this in advance of this meeting, but I was just having a problem with the bill, tracing it back and forth to those 21 pages. I was told when we first came to the legislature that if you don't understand a bill, you should vote no on it. I think, that has an implied warranty that you'll actually try, which I think I have. But I think the piece that's missing here is a good LSO presentation of it, a PowerPoint that walks through the major issues here, really explains all these. The working group has done an outstanding job. I mean, they've worked hard on this and have brought up all the relevant arguments. But what's missing is that bridge between all of that and the committee to really understand the underlying issues. If I was asked to present this bill on the floor, I really couldn't do it. And so I have to vote no on this for that reason. Perhaps I'm the only one that is in that position. So I respect yes, vote on this, but for myself, I have to vote no. Thank you, Mr. Chairman.
Any other comments? If Representative Obermuller, if in a cleaned up version, that's what we try to do during the interim. And oftentimes all of us know we're working on the fly and we don't have enough time to work a lot of this legislation or as thoroughly as we'd like to. If in a cleaned up version, do you think you would understand this and be able to present it on the floor?
Mr. Chairman, I'm just saying that today, when I'm being asked to vote, that with the understanding that I have of this bill right now, that I would not be able to explain it on the floor.
Okay.
And that's just today. I mean, with further study, maybe. So that's why I'm just thinking it's a great, it came, the way it's progressed and the way the interest group has worked on it, and then the LSO's relationship to them, our relationship to them and LSO, it's all really kind of confusing to me right now. So today I vote no. I think it's a good interim topic. I don't have a position one way or the other, I guess, because of my lack of understanding of it. But I'd like to see it as an interim topic. Thank you, Mr. Chairman.
I see. I would add just a little bit of history. I don't want to belabor this, but we've been doing this probably since I've been on transportation. Stan would have the best recollection of it, trying to deal with salvage titles and how to take care of people's property, their titled property, and yet protect the towers and the industry that has to clean them off the highway and other things and all of the interest. And it's been very confusing. It's been very confusing. I think this adds a few more pieces to what they need to be able to work and manage as an industry.
Mr. Chairman. Mr. Chairman.
Yes, go ahead.
Thank you. With all due respect, your prior knowledge doesn't help my knowledge right now. It came to me 4 o'clock on the agenda in September with a 21-page document. I mean, that's how complicated it is. And so, I mean, it's sitting there with different, I know this is a problem you have with committees, but I think if the next committee makeup took it up early on, perhaps we could all, or perhaps I could understand it. I don't want to speak for anyone else on this committee right now. And if everybody's comfortable with it, just vote yes and move it. But I'm not the one that could present it. So Thank you, Mr. Chairman.
Thank you, Representative. Representative Anderson.
Senator Anderson here, Mr. Chairman.
Oh, Senator.
I'd like to call a question, Mr. Chairman. I think we've discussed this quite enough. Thank you.
Question's been called for. Mary Beth, go ahead and take the roll.
Mr. Chairman, this is a roll call vote on 21 LSO 247, version 3 as amended. Senator Anderson.
Aye.
Senator Hutchings.
Aye.
Senator Pappas.
Aye.
Senator Steinmetz.
Aye.
Representative Blake.
Aye.
Representative Brown.
No.
Representative Crank.
No.
Representative McGuire.
No.
Representative Newsom.
Aye.
Representative Obermuller.
No.
Representative O'Hearn.
Aye.
Co-Chairman Von Slater.
Aye.
Co-Chairman Eklund.
Aye.
Mr. Chairman, that bill passed.
Okay. Thank you, Mary Beth. Next item of business is airport districts. How do we want to do this? Do we want to go through the bill? Have Heather go through the bill and then we'll bring on testimony?
Yes, Mr. Chairman.
Okay. Heather, go ahead and walk us through the bill, please.
Mr. Chairman, this is looking at 21 LSO 0264. And what this bill does is it uses the notion of special districts that is throughout statutes and authorizes counties and municipalities to create airport districts. And in the doing, it goes through and specifies requirements and it specifies what's pretty standard throughout the other special districts that exist, as far as specifying what they can do and what their makeup is. The main difference is that there are airport boards that already exist, and so this just goes in and specifies how that will translate, how those will kind of transfer into a special district should a municipality or county want to do that. And then there's various duties of the Aeronautics Commission and airport districts that would need to be accomplished that they already existing need to do and to create their existing obligations. So going on to page 2, the new creation, there are 3 new sections that are created, and that's 10-5-401 through 10-5-404. 10-5-401, the airport districts that's being created, it's saying that each Board of County Commissioners that has established an airport board that has established an airport or airport board, that they may do complete a resolution to create an airport district. And then there are some requirements that they must meet. The airport district needs to be composed of lands that are within the county or municipality that plan to participate. And that also, if the airport board, now I'm on page 3, if it had been formed jointly already, that the county or municipality needs to also participate in that resolution and adopt a resolution accordingly to create this board. And the resolutions, because the board was already in existence, paragraph 3 on page 3 talks about the resolution needs to provide a plan to transfer to the district all the responsibility for the operation of the airport and any ownership or what have you that was held in the board. Subsection B, it gives a time frame that not less than 60 days before this resolution that's adopted by either the county municipality or jointly, that the Board of County Commissioners shall submit that to submit it to review to the county assessor to just confirm that all of the land and the composition of the airport district is correct. And then subsection C is after the adoption of the resolution, that's in subsection A, again, the airport district shall be a corporate body, and they can refer to themselves, now I'm on page 4, as the blank airport district. And they are now operating as a corporate body with the many things that a corporate body can do, as far as suing and being sued and have a perpetual existence. The participating counties and municipalities that are adopting the resolution, they shall file with the county clerk a certificate that shows that the county or that the district has been created. Subsection D accounts for if lands are to be added or subtracted from the district at some point in the future, then another resolution similar to the way it was executed in A would need to be created or would need to be passed. And then subsection E provides that, see, there is this section, the Special District Elections Act of 1994, that applies to special district, and this is unless otherwise provided, that shall apply. 10-5-402, starting at the bottom of page 4, but then it is the powers management and how to remove folks, and then dissolution. And so it goes on to page 5 that it specifies the governance of an airport district, and it shall be consisted by a governing board that is going to have not fewer than 3 and not more than 9 appointed qualified electors of the district. It tells how they will be formed, the fact that they will be decided on by mutual agreement among the governing bodies of the counties and municipalities that are located within the boundaries of the airport district. and it tells the terms and that they shall be staggered. Subsection B, the airport district governing board shall organize each year by, having a president, vice president, and secretary, treasurer filling those roles. The reason it's specified to as filling the roles is that if they only have 3 people, that there would be someone filling more than one role. No individual member of the board shall be personally liable, so this addresses liability. And this also addresses the compensation, that they will be compensation similar to other people who serve on boards. And specifically at the top of page 6, it specifies to the same manner and amount prescribed for legislators in that statutory section. Subsection C is that it specifies that the airport district or governing board may exercise all powers granted to municipalities and counties under Wyoming statutes 10-5-101, which lists those powers. Subsection D, the airport district governing board may appoint a full or part-time manager and other personnel to operate the airport and compensate them properly. And subsection E is the airport district governing board is authorized to enact ordinances and what they need to establish and operate the airport district, and they need to file any ordinances that they enact with the county clerk. And they also need to administer their finances according to the Uniform Municipal Fiscal Procedures Act. So this is just giving them some guardrails to work within. Subsection F is that the governing bodies of the participating counties and municipalities may remove any member of an airport district governing board for cause without public hearing unless the member requests that action be taken during a public hearing. And then it addresses vacancies. So vacancies on the governing board shall be filled by the governing bodies appointing them as they had originally done it to appoint someone for the unexpired term. Subsection G is that an airport district may be dissolved by a resolution of the county commissioners or if it's joint, then by the other governing bodies that participated in it. And if that happens, then a resolution that dissolves one shall provide for a plan to transfer or otherwise dispose of all of the responsibility for the operation of the airport and debt and facilities. Section 10-5-403 is about taxation, and there's a limitation expressed in there. And subsection A is that an airport district governing board may submit to the qualified electors the question, and moving to the top of page 8, of whether to levy 3 mils on the dollar, or not to exceed, it doesn't have to be 3, to operate the district. And then the rest of that subsection is the process of submitting that to the electors of the area. Subsection B is that the Board of County Commissioners in each county in which the airport district is located, at the time of making the levy for county purposes, shall levy the tax upon the taxable property within the airport district to be used solely to operate the district if it's approved. So that's just the mechanism of how it would be enacted. And then it specifies that those monies shall be in an account for the airport district governing board. 10-5-404 speaks to the issuance of bonds, notes, warrants, and other securities. And this specifies that if there's a majority vote of the members of an airport district governing board, the board may issue revenue bonds, notes, warrants, and other revenue securities for the purpose of this article in the same manner that's provided in 35-2-424 through 35-2436 for the trustees of hospital districts. The trust that lays out then a lengthy or a detailed process. So it's referred to the process at that section, those statutory sections. Those were the created statutes. And in section 2 of this bill at the bottom of page 9 are the statutes that are affected that need to be either conformed or adjusted to account for the airport districts. So if you starting at the bottom of page 9 with 10-3-201, and this is about the powers and duty of the commission. The Aeronautics Commission, that it just specifies that commission shall cooperate with, and it adds airport districts to the list. And that's what's happening on page 10 and on page 11 and at the top of page 12. It's adding airport district to the list of folks that that the commission shall cooperate with, and that grants and aid can happen. It's any place where there was an airport. The airport district is now included in the group of municipal organizations. And also, that is also page 12. It's just the slight difference in subsection B that's listed there. And at this point, we're in statute 10-3-401, which is talking about grants and aid for airport construction and improvement, or an air service promotion. That is simply, it had been omitted about joint powers boards when earlier in that subsection, or earlier in that section, joint powers boards were included. So that is just making those consistent. The bottom of page 12, 10-5-101. This is the powers of municipalities with regard to acting and in some of their abilities to act. It is going to include on top of page 13 that they can establish an airport district according to statutes that we have gone through. And that's in both subsection A and B, as far as establishing the district according to and enforcing the rules that we were just, well, establishing it according to what was just created and enforcing the rules that would be promulgated thereof. 10-5-301 is the powers of counties. And so this goes in and specifies that the power that counties have the power to do this as well. So this is just the other side. So it says that the created provisions said that they could create them. So this is now going into counties and municipalities to add it to their list of powers to make sure that they cross-reference okay. And that's on page 14 as well. You'll see that airport districts is being added to those statutes. And same with page 15. And at this point, we're in Title 16, which is still the different county statutes. And it's, but specifically 16-12 is a section that refers to, of the Wyoming statutes that is all about special districts. And so in that subsection A, when it says this chapter applies to the following entities unless otherwise specified, all of the paragraphs numbered that are above 24, which you see that inserted 24 at line 7 on page 15, all the ones that are listed above that are a bunch of other types of special districts. So this is adding airport districts into that list. And the same with now moving on to Title 22, which describes elections. Well, there's a section in the elections statutes that says this act applies to the following districts, and this is adding airport districts into that list of special districts as well for how elections would apply. And then Title 39 is Title 39 are the taxation statutes, taxation and revenue statutes, and there is a section at 3917-111. 3917 is the fuel tax, and there's a portion of the gasoline tax and a portion of the diesel tax that had specified that they go to an airport. So this just goes into that section and specifies to the airport district, city, county, or town where the airport is located. And so that is the what you see on the page 15 and page 16 and page in 3917.311 is alternative fuels. So we have gas, diesel, and alternative fuels, and it's just adding airport district into that distribution for the taxes. And then it's the effective date of that. That's it, Mr. Chairman.
Thank you, Heather. Questions for Ms. Jarvis? So I'm not seeing any. I think we'll move into public.
Representative, Mr. Chairman.
Senator Hutchins, go ahead.
Just a quick question. Did she was mentioning that they're requesting a portion of the fuel tax. Did I hear that? I just want to make sure I'm listening correctly.
Mr. Chairman, they're not requesting a portion of the fuel tax. The fuel tax, a portion of the fuel tax is already distributed to airports. And so, for example, the distribution paragraph is very similar in each of the one for gas and the one for diesel and the one for alternative fuels. And it's very similar. And basically, it tells what that share is. And it says that that share shall be distributed, the remainder to what it previously had said before adding an airport district. It had said shall be distributed to the city, town, or county where the airport is located. So now it just simply says to the airport district, city, town, or county where the airport district is located.
Gotcha.
So it's already a portion of the tax is already going to the airport. This is just a locational thing, basically, of saying that it should go to the place where the airport's located.
Gotcha. Thank you.
Okay, not seeing any other questions. Mrs. Wright. Whoops. No, Joe. Representative McGuire, go ahead. I see you there.
Mr. Chairman, this would be a question, and I don't expect a immediate answer, but maybe to think about. And that is, it's brought to mind by here in Casper. The hospital was originally built by the Wyoming legislature, and then eventually it was sold to an out-of-state company. And I'm just wondering if we should include language in this bill that, let's say in the future, an airport was no longer viable for air transportation, but the land became more valuable, just to make sure that this isn't used as a tool for those properties to be sold to an out-of-state company, maybe as a land acquisition or something like that. So I would just invite Ms. Jarvis to kind of think about that a little bit.
Mr. Chairman, Representative McGuire, are you suggesting something beyond that, the section that talks about how an airport district may be dissolved and that it shall have a plan for to dispose of or otherwise transfer the various property and debt and things? So if I'm understanding correctly, are you suggesting perhaps something in addition to that? And on page 7?
Follow up, Representative McGuire.
Yes, Mr. Chairman, Ms. Jarvis, insofar as maybe additional language that upon dissolution, it would not be sold to a private entity, especially an out-of-state private entity, or maybe a multinational entity. Because again, one of the most valuable things that a lot of these airports have is the real estate. Thank you, Mr. Chairman.
Okay. Senator Steinmetz, did you have a question? I don't see you now. Okay, I'll go to Representative Obermuller next, then I'll come back to you, Sherry. Go ahead.
Yeah, thank you, Mr. Chairman. Ms. Jarvis, I think maybe you've already indicated this, but can you just inform us of what problem we're solving with this bill? Thank you, Mr. Chairman.
Mr. Chairman, Representative Obermuller, I don't want to be in a position of advocating for or against something. I just know that the intent was to allow municipalities and counties to create airport districts, to authorize it because they were not previously authorized to do so. So that's what this bill is doing. I think perhaps Ms. Urbicite could speak to the need or desire for that request to have come to me.
Can you follow up, Mr. Chairman?
Go ahead.
Yes, Mr. Chairman, if there's someone else who can address what problem we're solving, I would appreciate it. Thank you, Mr. Chairman.
I think that's a really good question because I'm wondering if we've functioned well with airport boards for a long time, how this improves it. That's probably, I was wondering the same thing. So when we, pending no more questions from the committee, I think we'll go to Mrs. Urbicite and you can answer that question and probably speak for the bill and why it's before us.
Mr. Chairman, thank you. Lori Urbicite with the Wyoming Airport Operators. Actually, I'd rather punt that question and an explanation of why the bill was brought to Devin Brubaker from the Southwest Wyoming Regional Airport. He's worked on this legislation and this concept for quite some time, and he'll give you far better answers than I am able to, and I'll save my comments for public comment if necessary. So I thank you, Mr. Chairman.
Okay, we will go to you, Mr. Brubaker. Go ahead and teach us a little bit about why we need the bill and why this is an improvement.
All right, Mr. Chairman, thank you for the time today. Committee members, my name is Devin Brubaker. I'm the airport director for the Southwest Wyoming Regional Airport here in Rock Springs. I also serve on the board of directors for the Wyoming Airports Coalition, and I speak on behalf of both of them today. Before I get started, if it's all right with you, Mr. Chairman, I do want to do a quick thank you to 3 of your committee members that I've had the privilege of working with over the last couple of years that will no longer be with us as legislators here in the next few weeks. Senator Von Flattern, Representative Blake, and Representative Crank, all 3 of you I've had the privilege and the honor of working with on aviation and economic development related legislation. And it's been an honor to work by your side on those bills. And I wish you luck in your future endeavors and thank you for your service to the state of Wyoming. On top of that, I would also like to thank the LSO staff for their efforts over the last several months helping me with this legislation. Wyoming's 40 public use airports provide critical connectivity to each community that they serve, providing immense economic activity throughout the state of Wyoming, supporting nearly 10% of the statewide employment, 1.3 billion in annual economic activity, over 80 million in state and local tax revenues, and over 20,000 jobs. Yesterday, you heard testimony from WYDOT regarding the 45 million in annual unfunded capital investment needs for Wyoming airports. Combined with operational deficits, Wyoming airports need at least 55 million per year in funding to be able to ensure a safe and secure air transportation system that generates immense economic value to the state of Wyoming. We recognize that these funding needs cannot be covered by the state of Wyoming or local government entities. Only 3 of our state's 40 public use airports are financially self-sustaining. The other 37 require over 10 million each year in financial support from counties, cities, and towns to cover labor, maintenance, utilities, and capital costs. Furthermore, many of Wyoming's airports are run by either an airport board or a joint powers board and are subject to the statutorily mandated requirements of special districts. However, airport boards and airport joint powers boards are not given the same authority to go to the voters to seek financial assistance. We recognize the financial demand that our operations place on local entities, causing government bodies across the state to split limited resources between economic activity and connectivity and other important services to the residents. In an effort to deliver a solution that will help local governments, we have looked across the country for successful airport governance models. The most successful models that we have found are airport districts and/or airport authorities. They're similar organizations, just different in name. They each allow for local communities and their residents to have local control over how their airports are funded. This governance style allows for the imposition of mill levies to support airport operating and capital expenditures. We studied statutes that authorize the creation of various types of districts across Wyoming and suggests that this draft bill is a great start to ensure industry improvement and sustainability through local control measures. We've had preliminary discussions with the Wyoming County Commissioners Association and the Wyoming Association of Municipalities and look forward to continuing to work with them as this bill moves forward into the session. An airport district allows voters to support the value of their airport without competing with other services that are funded with local general fund dollars. They allow for communities to ensure that they have necessary funding to compete for FAA Airport Improvement Program grant funds that require a local match of 2.5% to 10%. We need to have those funds available at a moment's notice to accept them. The formation of a special district would allow for the funding necessary to ensure that federal dollars are never turned away. It provides a level of confidence in future funding for grants and improvements that is not available in Wyoming today. Federal Aviation Administration funding is competitive, and having the ability to say yes to an unplanned grant with little notice is only possible for 3 airports in Wyoming. If we want to position Wyoming to compete for these federal dollars, we need to be sure that we have the ability to match them. There are also projects and improvements that are not eligible for grant funding, but just as important to the airports and the communities they serve. So any funds generated from a special district could assist in those improvements and operations as well. We have made a concerted effort to find a solution in a time where they are needed more than ever. Airports are key economic drivers to the communities they serve and the state of Wyoming. Their fiscal health is paramount to ensuring they continue to drive economic activity and growth across the state. By providing communities with a new tool in the toolbox that allows local control, our state's airports and the communities they serve will be able to thrive for decades to come. We ask you to support this legislation, and we thank you for your time and consideration. We're happy to answer any questions you might have.
Committee questions? I'm not seeing anyone. If I'm missing someone, you need to speak up. Okay.
Chairman.
Yes. Oh, Representative Newsom, go ahead.
Thank you so much, Mr. Chairman. I have a question about the use of the funds. So if the voters were to pass the 3 mills, is there any restriction on those funds, on how those funds can be used? Just curious about any sort of governance in this bill that would restrict use of the funds.
Mr. Chairman, Representative Newsom, very good question, and I appreciate that. This bill does not call those specific things out except for the operation of the district. However, airports are federally obligated, and part of that federal obligation is that there's a revenue use policy that the Federal Aviation Administration requires airports to follow. And so it limits where funding can be spent that is generated by the airport, whether that be through a mill levy or through revenues generated from the operations of the airport. So it's federally regulated on what those funds can and cannot be used for.
That answer your
Thank
question?
you.
Okay.
Yes.
Ms. Jarvis is waiting.
Oh, yes. Heather, go.
Mr. Chairman, the bill draft does have just the very basic, like is often put specified at the top of page 9 as solely to operate the district. And that is, as Mr. Brubaker said, then there are other rules for operating it, but it does have that requirement. So, and the district governing board is who can access it to operate it.
Mr. Chairman, I have a question.
Yes, go ahead. Senator Steinmetz.
Thank you, Mr. Chairman. And I apologize if this has been asked. I had someone at my door that I had to go let in. So on page 6, and this is either for Heather or the gentleman who was just testifying, on page 6, under section C, which is line 4, the airport district may exercise all the powers granted to municipalities and counties. And then under section E, they are authorized to enact ordinances necessary. So I just wondered if any other special districts have the same powers of municipalities and counties. I was trying to look it up, but I wasn't finding anything. And then why we would want to allow them to enact ordinances, just a little discussion on that, if you could help me out there. Thank you.
Mr. Chairman,
Yes, Heather, go ahead.
that 10-5-101, it's, let me back up, on page 6, subsection C, it's not granting all powers that are granted to municipalities like across the board. Specifically 10-5-101 is actually in the aeronautics section of the statutes, because Title 10 is aeronautics. And so 10-5-101, the powers of municipalities and counties generally with respect to aeronautics, it lists that in that instance, for example, that municipalities and counties can, they're authorized to acquire by lease, purchase, or otherwise lands and property for the airport, construct, maintain, and operate terminal, office, traffic control, and non-aviation buildings and warehouses and barracks, meteorological facilities. I'm not trying to gloss too quickly over it, but that one section is very specific to aeronautics. And it's the powers that were granted to municipalities to operate an airport. So it's saying, well, then if it's going to be a district operating the airport instead, they can do those things that was told that they could do. Another one is in that list, for example, is install, maintain, and operate markers, lights, and other aids to air navigation things. So whereas the city could do it, well, now an airport district would be able to do those things. That's what that one is. And then as to your other question, I think Mr. Brubaker, I don't know if you were started moving to speak. I didn't know if you were moving to speak to that one or the first one.
Mr. Chairman and Mr. Jarvis, I'm happy to address either of them, but I think you covered the first one very, very well. The second item, Senator Steinmetz, this is language that allows an airport to institute its own rules and regulations to govern the operations of the airport only. So in terms of making sure that aircraft and tenants operate within the rules and regulations, it allows for the creation of ordinances that are only applied to the airport itself. This is fairly standard in our industry. The FAA requires us to have rules and regulations as airports, and this allows us to essentially locally codify them to be able to have those executed at a local level, and then, if so, supported by local municipalities to be enforced.
Heather.
Mr. Chairman, additionally, the Special District Elections Act that governs other special districts, that does specify how, I'm sorry, Mr. Chairman, Senator Steinmetz, that does specify how other districts, as well as then airport districts, would enact ordinances and things to govern themselves. So I think part of your question was, do other special districts do this? And yes, in fact, it's in that Special Districts Elections Act how to do so.
Okay. Any other questions? Do we have further testimony concerning this bill?
Mr. Chairman, I believe Brian Olson is available from WIDOT if the committee has any questions.
Mr. Olson, would you like to speak?
Thank you, Mr. Chairman. I don't have any additional testimony other than to say that we don't have any issue with this as the draft is written.
Okay, thank you.
Mr. Chairman.
Ms. Zervkite, go ahead.
Thank you, and I'll be very brief. I just want to reiterate that the Wyoming airport operators are very, very clearly cognizant of the fact that the Wyoming financial situation is not in in perfect shape. This is simply one more tool in their toolbox that they can help fund their own operations. I think they should be commended for bringing this forward. And I'm certain I don't need to tell anyone on this committee how valuable our airports are to us and how truly needed they are in all of our communities that are operating airports. So I would urge you to move this bill forward. We're happy to work with the committee in any on any amendments that may be considered. Again, it's our first step in trying to help fund the airports of Wyoming without being a drain on the general fund or on the municipalities and counties. Thank you, Mr. Chairman.
Thank you.
Representative McGuire.
Yeah. Yes, Representative McGuire.
Thank you, Mr. Chairman. I was just wondering, this is a question for Brian Olson. If he knows which airport located in central Wyoming is financially self-sustaining.
Gee, would that be Casper?
Oh, yeah, I think that would be Casper. Best airport in central Wyoming, I think they call it.
I think it's the only international airport in Wyoming too, isn't it? Okay.
I think it is, Mr. Chairman.
Okay. So are we finished with testimony? Is there any further questions the committee has? I don't see any. I don't hear anything. What's your pleasure, committee?
Move the bill.
Second.
Moved by Brown and seconded by somebody. Von Flatern. Thank you, Chairman. Discussion on the bill. Are there changes to be made?
All a question.
Mr. Chairman.
Oops, there is a question here. Senator Anderson.
Mr. Chairman, page 3, line 3. It's going to get all the participating counties and municipalities to agree to this. We've had a little problem with that in our county. We have 7 entities, counties and municipalities, and it's a little difficult to get them all sometimes. I would like to propose a amendment to that to strike by all and put in at least 70% participating counties and municipalities.
Mr. Chairman, where are you on this?
Page 3, line 3.
Not necessary.
Mr. Chairman.
Yeah, go ahead.
So Senator Anderson is under the understanding that all 100% of, I didn't see this. I kind of lost on this. All participating counties and municipalities, an airport or airport board is performed jointly with more than one. Oh, one county or municipality, the resolution's up. So you have Casper.
So we have 7 entities. Yeah.
7
yes,
entities.
we do. Yeah. Every time we try to get something through, we have to get all of them to agree according to this.
Mr. Chairman, we need a second on this before we continue with
Yeah,
discussion.
that'd be great.
Do we have a second? I'll second it. Let's go ahead and discuss it a bit. I didn't hear a second, so go ahead. Senator Anderson, I'm not, and maybe we're going to need Heather in here. I'm not sure what this means either.
So, Senator.
Yeah, go ahead.
Mr. Chairman, if I can talk about adopted by all participants. So who owns Casper Airport? Is it Casper County, Natrona County?
Yes.
So you only have to get Natrona County?
No, you'd have to have all the participating counties and municipalities. And that's where the taxing is going to occur, is in all the counties supposedly. But our county is unique with 7 entities that have to okay that. But another airport could go for 2 or 3 counties and then have to have all the municipalities and counties within that okay the thing before they could form it. I think getting all participating counties and municipalities to agree to this is a little bit of a high standard.
So, Ms. Jarvis, Chairman, I would call him Ms. Jarvis.
Yeah. Heather?
Mr. Chairman, committee, I have no opinion one way or the other, but it seems as though paragraph 1 on page 2 would need to be addressed if this is what the committee is considering, because page 1, paragraph 2, which Senator Anderson spoke to, talked about adopting the resolution, and page 1 talks about that a county can only create one of these if the airport district is provided that the airport district is to be composed of lands within counties and municipalities that plan to participate in the district, which are not within an existing airport district and which are not within the boundaries of a county or municipality that has appointed an airport board under 10-5-202, unless the governing board of that municipality elects to participate in the district. So those are some other qualifications that have to do with where the airport is located and who needs to agree to create this district. It seems like that may be a part of this, because the idea of these paragraphs was basically everyone is going to get on board, and if not, we might need to adjust several paragraphs.
Mr. Chairman.
1 and 2 mainly.
Mr. Chairman.
Representative Brown.
Thank you, Mr. Chairman. Based off of Ms. Jarvis's information there, I guess I would open up a quick question to Brian and or Devin on this and ask how many of these throughout the state we don't have already that would need to be opened up to this level, because it seems to me that we have a lot of these. And so concerning Senator Anderson's point of if Natrona County has some issues with this, does Natrona County already have an issue, or does Natrona County already have this and they won't have to worry about this? Or are we trying to set up for, 2, 3, 4 individual areas that don't have this? And what kind of an issue are we creating by putting this language in there?
Mr. Chairman, may I interject before they answer that question?
Go ahead, Senator Hudson.
My either statement or question is, there are no airport districts. This will be the first one. Is that correct? Thank you.
Mr. Chairman, there are airport boards which may be supplanted by this if they so choose, but no airport districts yet.
Mr. Chairman, this is Devin Brubaker. Representative Brown, if it's all right to address that question.
Go ahead.
So, Mr. Chairman, Representative Brown, an example that I can think of right off the top of my head would be, say, Fremont County, where you have a general aviation airport in Lander and a commercial airport in Riverton. I can't speak for those communities and how they would react to this legislation, if they would utilize it or not. But there could be a situation in the future where they decide they want to join forces and have a single organization that runs both airports for those communities to take advantage of synergies and things like that. So that would be one example where there's not an airport board or a joint powers board that exists today, where there could be a situation where you might need to have multiple municipalities vote to be part of it when they currently already operate their own airport board. So I don't think I'm opposed to the amendment as it's been brought, but I don't know that it's necessary because of the language on the previous page. It puts definers on why that paragraph is required. It's if it's done jointly, it requires, and it's not going to be done jointly if those entities aren't going to agree to it anyway. So no different than a joint powers board. You're not going to join a joint powers board unless you're going to agree to be joining it. So it basically is very similar to that, is how I interpret it.
Mr. Chairman, a follow-up on that, if I could then. Devin, as you say that, let's use the example you used with Lander and Riverton. As it stands right now, the current language that's in there, it would require if Fremont County as a whole decided they wanted to go ahead and adopt a airport district throughout all of Fremont County, as written, everybody within Fremont County would have to agree to this. All of the municipalities, anything like that, and that money could then be dispersed to one or the other of those two airports. However, if that money, let's say Lander is the one who decides they want this and they want all the money, they can actually go forward with this and they could try to shun out, if you will, or kind of isolate around Riverton. If they go get everybody else involved and get all of the municipalities, with the way Senator Anderson's information is, they can get 70% of Fremont County less Riverton, and have a Fremont County board that would then encompass and give all the money strictly to Lander and leave Riverton high and dry. Is that correct?
I think with this amendment, that would be possible. And so with that in mind, I like the language as it's written. So I appreciate that question. And I apologize, Mr. Chairman and Representative Brown. I like the language as it is. And I think with amendments, it could create that situation. In theory, you would hope our local communities are working together, but we know sometimes that doesn't always happen. So as it's written, it protects that. It requires 100% involvement. And I understand the situation in Natrona County is difficult with that many municipalities involved. But the situation may exist where the special district in Natrona County is only on actual airport property. I believe that airport's almost 6,000 acres. I'm sure Representative McGuire knows the exact acreage of it, but almost 6,000 acres. And it may be a situation where they have a special district only on their property to help maintain the road infrastructure on that 6,000 acres. So I think it's important to recognize that just because this allows for it to be an entire county or multiple counties, it could be as small as a small municipality or just the airport property itself.
Thank you.
Okay, any other questions? Senator Anderson, is that?
Mr. Chairman, the problem that you have here, you're trying to put in 3 mills, and you want to put that in as much as you can into your county or the counties. You wouldn't want to put it just in an airport because you wouldn't get very much revenue off that. So the 3% or up to 3% needs to be in a broad area that has some value that you can get revenue from. So I can see other counties going, multiple counties, to support their airports. Sweetwater might want to include Uinta or Carbon or some others, and they could get up to 7 or 8 different municipalities that may have to agree to that. So I still would like to have that all are not agreeing to this portion. I picked 70% because that turns it down to 5 for us.
Mr. Chairman, Representative McGuire.
Yes, Representative Von Flay, or Chairman, go ahead.
Well, I'll take over as chairman for a little bit.
Okay.
You're
what I've got to tell you folks, you're all in still life. So I see something that seems to be have happened 10 seconds ago. Go ahead. Go.
Mr. Chairman, and this would be a question for Ms. Jarvis. So I'm looking at page 2, line 21, where it says that the municipality elects to participate. The question that came to my mind was, does that mean an electorate of the people who live in the county, in the municipality? Would it be like a special election? Or does that mean that the municipality during a regularly held meeting could agree to enter into it? So I'm wondering if we want to change the word elect and if maybe that would help to.
Mr. Chairman, Representative McGuire, it's the governing board of that municipality, and elects is in the instance of chooses. So, but they would need to, I mean, they couldn't just choose. It would be at a meeting as you suggest. So perhaps unless the governing board of that municipality votes to participate in the district, they're choosing, it takes action to participate in the district. It's the idea but it's the board themselves. So if you see at the end of line 20, it's not just the municipality, but it's the governing board of that municipality. And so it's the way, it's however they would conduct business to choose to do something, to elect to do something.
Thank you. That answers my question.
Okay, so we have an amendment on the floor. Are we ready to vote? The discussion is over. And the amendment that we have is to change from all participating counties and municipalities. I'm on page 3, line 3 and 4, to 70%. Correct, Senator Anderson?
Correct.
Okay. All those in favor of that amendment, raise your hand. Okay, I'm seeing 4. What do you have, Mary Beth?
A lot more than 4.
Mr. Chairman, I counted 5.
5. All right. All those opposed, raise your hand.
I'm opposed.
Well, some people I think are not voting. You're still in there. We go, there's more of them. So I have 7.
You get me, Mary Beth? Good.
What did you have, Mary Beth?
Mr. Chairman, I had 8.
Okay. All right. So that amendment fails. Any further changes to the bill? Yes, Representative McGuire.
Thank you, Mr. Chairman. This is another question for Ms. Jarvis. So I'm on page 5, paragraph B, talking about immunity for the board members. And of course, finding board members is always extremely important and can be a challenge if professionals think that there will be some liability. So I'm sure you thought about it, and I looked around and I could find the statutes for the state appointed boards and other immunity provisions, but I couldn't find anything specifically for this type of a joint powers board. So I'm just curious if you think it would be better if there was a specific statute cited, or if you obviously you feel that just saying the statement personal liability, if you feel that that will be sufficient in this instance. Thank you.
Mr. Chairman, Representative McGuire, there is that statement there that no board shall be personally liable. It may be that, just a moment, I'm just looking for it may be that there could be another statute to cite to. It's largely modeled after the formation of other special districts. However, there may be key idiosyncrasies for an airport district that may want even more liability protection. So I'm just looking to see if it might be good. I'm looking at municipality statutes and liability statutes. If it's okay with you, I could keep looking. If there are other questions, I could look at this up while the other questions are discussed.
Okay, are there other questions? Go ahead, Representative McGuire.
Thank you. And again, this is for Ms. Jarvis, so this will keep you occupied while you're looking at. So I am on page 7, line number 18. And again, my original question about, so there's a district that's formed, and then at some point, the municipality or the county decide that they don't want to support that airport. I want to make absolutely sure that the property would revert back to the original entity. So I'm looking at line number 18, where it talks about to an accepting agent entity. I think it would be more appropriate that it reverts back to either the municipality or the county to make sure that it's not going to be sold to especially an out-of-state company to be used as a real estate play. So I'm just curious if you have better language than that. Thank you.
Mr. Chairman, Representative McGuire, based on your comment earlier, I wondered if it might meet the need by saying, as far as just for that whole sentence, the resolution shall provide for a plan to transfer or otherwise dispose of all responsibility for operations of the airport and to the extent necessary, ownership and debt related to airport facilities to an accepting public entity. That would not mean reversion, but I don't know if it would always be reversion to whoever previously owned it, so much as if you were to insert accepting public entity, then that would ensure that it is not a private entity.
Okay, that would be good for me, and I would propose that as an amendment to the bill.
Okay, do we have a second? Second by Crank. Discussion on that amendment. Not seeing any. Oh, Representative McGuire, somebody, okay.
Thank you, Mr. Chairman. And I would just say that looking into the future, again, in the 1920s, when the state of Wyoming built the hospital in the middle of Casper, they had no idea that 80 or 90 years later, it would be sold to a private entity. I mean, they're just looking forward. There are so many things that can change, and maybe in 30 years, maybe there is no air travel anymore. Maybe people are going through the hypertubes or whatever that Elon Musk is proposing. So I just think it's very important. Again, I can't stress enough, here in central Wyoming, the most valuable thing that we have is the real estate. And I would just hate to see these small communities, somebody comes in, convinces a few people to sign off on it, and all of a sudden the most valuable real estate right next to that community is being sold to an out-of-state entity or maybe an out-of-country entity. So we as Wyomingites have got to stop selling our state. We've got to keep these, keep our assets local. And if the people decide, well, maybe it's best to sell that property, that's fine, but we have to make sure that a couple of maybe elected individuals don't have the opportunity to make these deals without everybody knowing what's going on. So that's why I would make that amendment, and I would strongly encourage people to vote in favor of it. Thank you, Mr. Chairman.
Mr. Chairman.
Yes, Senator Co-Chairman.
So where is this amendment going on lines on page 7?
Mr. Chairman, I can state it.
Yes, please.
Okay, Mr. Chairman, it is after accepting, inserting the word public.
Line 18.
Line 18.
Thank you.
Any further discussion on that amendment? Okay, all those in favor of Representative McGuire's amendment, say aye.
Aye.
Oh, I'm sorry. Raise your hands. Everybody raise hands.
I'm raising my hand.
All right, thanks, Senator. Okay, Mary Beth, I have 10.
Mr. Chairman, I can attend as well.
Okay, good. By golly, that That amendment passes. Now we have the other question that Senator McGuire had. Heather, did you have a chance to?
Yes, Mr. Chairman, the liability that is expressed on page 5, I'm sorry, the limit of liability that is expressed on page 5 is the amount of liability almost verbatim that is currently expressed for an airport board. And it's also the same as what is for a joint powers board. So I'm only partially responding to his question insofar as that it is what is existing for other boards, but I've not found another instance of an additional liability limitation statute to cite it to.
That's fine with me, Mr. Chairman. I just wanted to check. So thank you.
So you're good with the way it is?
I'm good.
All right. Any further changes or discussion on the bill? Okay.
Question, Mr. Chairman.
Question's been called for. Go ahead, Mary Beth.
Mr. Chairman, this is a roll call vote on 21 LSO 264 version 4 as amended. Senator Anderson.
Aye.
Senator Hutchings.
No.
Senator Pappas.
Aye.
Senator Steinmetz.
No.
Representative Blake.
Aye.
Representative Brown.
Aye.
Representative Crank.
Aye.
Representative McGuire.
Aye.
Representative Newsom.
Aye.
Representative Obermuller.
Aye.
Representative O'Hearn.
Aye.
Co-Chairman Von Slater.
Aye.
Co-Chairman Eklund.
Aye.
Mr. Chairman, that bill passes.
Okay, thank you. Okay, the next bill for our consideration, unless we need a break or something here, we'll just continue on through. I don't speak up if you do, but okay, I think we can just keep going. Autonomous vehicles. Chairman Von Slater, would you like to have us walk through the bill first? How would you like to do it? You're the one that's done most of the work on this thing.
Well, I haven't done a lot on it, but I would be glad to have somebody walk through this.
Okay. All right. Heather, would you like to walk us through this?
Mr. Chairman, I would be happy to walk you through this unless Mr. Kirschmeyer from YDOT is eager to do so.
Mr. Chairman, Heather, I'd be happy to walk the committee through it, sir.
Thank you, sir. Go ahead.
Yes, sir. So just a reminder to the committee, this is a bill on autonomous vehicles. I just wanted to go over what we kind of covered when I briefed the group on the working group that we had put together last winter just to discuss this issue. It initially came up through the blockchain side committee, and it was initially legislation just on testing only. The blockchain reviewed that, and I notified the JTC that YDOT had put together a working group to explore this issue, and that we would like the opportunity to address it more holistically. The request was granted, and we kind of operated under the goal of successfully and safely implementing autonomous vehicles into the roadway system. We were given kind of 3 things to consider. The first one was to make sure that the bill was holistic. That means that it covered everything from testing through development and deployment and into integration. The second one is that it did it safely onto the roadway system. And then the third consideration was to make sure that it was permissive as possible. We didn't want the legislation to restrict AV vehicle development, testing, or operation on the roadway systems. So as we reviewed this problem set with the working group, we kind of prioritized things and kind of reviewed all of the options. I will tell you that what LSO got, and I sent a copy of the original to the co-chairs of both this committee and the blockchain, was YDOT's recommendation. We have a pretty broad-based working group. It's about 24 stakeholders and/or subject matter experts from YDOT. And as you can guess, there's not total agreement on everything. But what we did send you was YDOT's recommendation, and I will tell you that Heather forwarded probably about 90% or 95% of what our original language, recommended language was, and that's the bill that you have in front of you. Pending any questions, sir, we can go through the bill, or I can highlight for you the about half a dozen friction areas that you'll probably see when we go through it, whichever way you prefer.
Why don't you highlight those areas that we might need some discussion on?
Yes, sir. The first one is the notion of testing.
Mr. Kirchmeyer. Heather, you've got something.
Mr. Chairman, as Mr. Kirchmeyer pointed out, a large majority of their amendments are in this bill. Where it's not, or where there was, Mr. Kirchmeyer, he specified where there was disagreement or differing views, and that is called out. So when I inserted an amendment where there was disagreement, to my understanding, there's a staff comment. So as he's flipping through the bill, I don't know if Mr. Kirchmeyer wanted to represent those other folks, but it's called out in the staff comment as well as what the differing idea was.
Mr. Chairman, that's correct. So again, I can either highlight them for you on the front end, so you're ready when we get to them, or we can just address them as we get to them in the bill.
Okay, just go ahead. Go ahead and walk us through the bill as quickly as you can. We're running a bit behind.
I will do, sir. The first section, again, is just definitions. And I would note for the committee that we used the definitions in the June 2018 of SAEJ 3016, which is the industry standard for definitions in addressing this issue. What you will note is the term autonomous vehicle is removed actually from the definition section. That term is no longer used in J3016. And so we recommend using automated driving system or vehicle equipped with automated driving system as a replacement for that term to provide more clarity and align with the current language used in the industry standard. One thing I will note, you will see that we do recommend the addition of an automatic driving system data recorder. And we will see that later on in the bill. That is a friction point. There are some stakeholders who do not want the use of data system recorder put into the bill, or access to it by law enforcement after a crash, and I'll highlight those differences as we get to that section. You'll note that the LSO staff did say that previously it noted what was not an ADS. We removed that from our recommendation from this bill, simply because settling on using the definitions in J3016 we felt provided the clarity necessary. And we did not receive any negative feedback from stakeholders on that. Pending any questions on the definition portion, I do want to highlight, we did replace the term operator because that had so much lack of clarity about it with the term dispatching entity. And where that's important is the person that actually pushes the go button on the vehicle. And that will come into play later, and I'll highlight that when we get to it later in the bill on why it's important to highlight what a dispatching entity is from a human driver and the person who operates the vehicle. The final thing to note in definitions is the fallback ready user. And this gets to one of the friction points between stakeholders. We were told to provide a holistic recommendation, which included level 3 vehicles that can perform the dynamic driving task. You will note that we used the template provided by the Safe Driving Coalition as the genesis for this recommendation. And that template only addresses level 4 and level 5 autonomy. However, we determined after some research that there are some level 3 systems that again can perform the whole dynamic driver tasks. So going under the term of holisticness and being safe, the YDOT recommendation is we include the terms necessary to address level 3 vehicle systems. That is not a universal opinion by the stakeholder holding group. Some feel that it should just address level 4 and level 5. Go on to section 3121-102, operation of a vehicle by a human driver. This just gets into when a human driver may be able to take the controls if the vehicle has a driver station. And what we're looking at here really specifically are current level 3 systems and levels 4 systems. The assumption is that there will be level 5 systems that probably don't even have a driving station, a steering wheel, or any pedals like that because they'll be fully autonomous. I want to highlight here that we have general consensus here. However, there were a couple of stakeholders that did not agree with some of the wording, specifically pursuant to paragraph III and I4 under subparagraph A. And it was really just how we worded which agency or entity authorized waivers. Our original recommendation was that it be the waiver has been granted by U.S. Department of Transportation. However, the language that you see really refers to the applicable federal and state laws, which we are not opposed to. I will note that, however, there are some stakeholders who want refinement of that language. Pending any questions, I'll go on to paragraph 3121-103. The biggest thing here to comment is that some stakeholders wanted to remove some of the wording in paragraph I after laws, and that's noted in the staff comments. Pending any questions, I'll go on to 3121-104. Insurance. The friction points here are really centered around proof of insurance and insurance limits. YDOT doesn't take a position on what the legislature choose to implement as insurance limits. There were recommendations on 1 million for individuals and 5 million for manufacturers, but that's we don't have a position on that. We will note, however, that as far as providing proof of insurance, some stakeholders suggested that the proof be presented to YDOT. We don't recommend that because currently now proof of insurance is handled by the county treasurers, and we recommend that AVs be treated just like other vehicles, and that YDOT does not assume any responsibility for proof of insurance.
Mr. Chairman?
Yeah, Senator Anderson.
Mr. Chairman, I'm looking at that staff comment on page 10. It says some stakeholders recommend in paragraph I above at line 4 after laws. And if I look up at line 4, there's no laws in that line. There is, however, down in line 7, and I wonder if that's what that really means.
Mr. Chairman, Senator Anderson, let me quickly pull up my version because again, what we have here in the bill is about 90% of what we sent forward. I'll compare the two very quickly here.
Chairman, that's exactly what they meant.
Yeah.
Looks like it.
Yeah.
And I would agree, Mr. Chairman, Senator Anderson, I would agree.
So make a note of that. We'll fix it. Okay, continue.
All right, section 3121-105. This is one of the major areas where there was friction. Again, looking at it holistically with safety in mind, as directed. The language in the current bill is generally the same as YDOT recommended. I will highlight some differences specifically with notice to what stakeholders preferred. The first one that you can probably guess is access to data recorder information. That is a friction point for two reasons. One, it infers that a AV will have a data recorder, and that gets into design standards, which some of the stakeholders felt the state shouldn't dictate design standards. That's a federal responsibility. The second one was the fact that law enforcement having access to a data recorder information without a subpoena, they felt was probably inappropriate. From YDOT's perspective, what we wanted was to treat these vehicles as much as we could as normal vehicles. And from law enforcement's recommendations from patrol, they needed access to the information that they did not want it to be encumbered and have to go through a subpoena process in order to do an accident investigation. So the wording that you have in front of you and from the bill is generally the same as what YDOT recommended, but not exactly. And I would assume that Heather made some changes based upon current wording necessary or how to align with current statute, and she can make comment in that area. Pending any questions, I'll go on to 3121-106. On-demand autonomous vehicle network. YDOT officially doesn't take a position on how the legislature chooses to treat commercial AVs. So what we did is we sent the stakeholder recommended wording changes forward, and I believe that generally LSO accepted those. (3121-107), registration and titling of the vehicles. Basically, I don't have anything here to highlight other than we recommended the addition of county treasurer, because that's where insurance verification takes place into the original bill. And I believe that has been adopted on line 21, page 15. So our one recommendation, again, that's slightly friction with the stakeholders. Their recommendation is they provide the department with insurance verification, but we'd prefer it to remain the same as with other vehicles. (3121-108). We submitted the change to paragraph C, which was based upon stakeholder recommendation, and LSO adapted that. So I don't really have anything to highlight in 3121-108. 3121-109. There were a number of diverging recommendations from stakeholders on how to word this. and the adapted language is slightly different from what YDOT recommended. However, that being said, I don't believe that what you have in front of you, YDOT would disagree with. But I do want to note that there are a couple things in here that cause friction. The first one is a human or a dispatching entity having to be licensed to basically push the go button on the vehicle. Stakeholder input suggested that this could be overly restrictive. For instance, a mechanic, a truck mechanic would have to then have a CDL in order to move, legally move the truck around in and out of the maintenance bay. And that may not, yes, I'm sorry, I'll stand for the representative's question.
Mr. Chairman.
Go ahead. Representative McGuire.
Thank you, Mr. Chairman. I don't mean to start out by getting a little bit fussy here, but I just want to make everybody understand I'm here to represent the people of House District number 35. And I'm a little bit worried about this stakeholder. And I keep hearing about stakeholders, and stakeholders don't want to have people looking at data, and stakeholders don't want this, and stakeholders don't want that. Who are these stakeholders? Are they residents of Wyoming? Are they people that we've been elected to represent? I want to know who the stakeholders are, and I want you to let us know where these conversations are coming from and going back and forth from. Thank you, Mr. Chairman.
Mr. Chairman, Representative McGuire, fair question. The working group consists, sir, of stakeholder groups that represent the industry, automotive manufacturers, the insurance industry, truck manufacturers working in the AV workspace, the Wyoming Automobile Dealers Association, Wyoming Trucking Association. Some are Wyoming residents, some are not Wyoming residents. So it's kind of a broad-based group. We did try as much as possible to gain consensus. However, whenever we disagreed with a stakeholder, again, Wyoming at YDOT, we defaulted to, did we feel it was unsafe based upon their input? Did we feel that it was not holistic, meaning that it didn't cover all types of AV and everything associated with safely integrating the AVs onto the system, which is why we have some disagreement there. And then finally, was it too restrictive? So I'm just noting for the committee's review that where there's disagreement, and possibly these folks might talk to legislators later with regards to bill discussions further in the process. Does that answer your question, Mr. Chairman, Representative McGuire? All right. The other friction point in Operation Human Driver, the person dispatching or pushing the go button, having to be licensed in the type of vehicle. Again, they thought it would be overly restrictive. A point was brought up. Well, what about a 12-year-old? Sending the car on an errand. Fair point. That absolutely. If you do not make the person pushing the button to send the AV on its mission be licensed to operate that type of vehicle, then technically anyone could launch a vehicle, and that's again a policy decision. The other thing that caused
Chairman Von Flatern, go ahead.
Ms. Kirchmeier, can a person ride in the vehicle without the correct license? That would be another question.
Mr. Chairman, Mr. Co-Chairman, yes, the way this bill is crafted, when the autonomous vehicle is engaged for the purposes of being licensed to operate the vehicle, it is considered licensed to operate a vehicle. So in the case where you might have an Uber or a Lyft that's fully autonomous and someone orders it on their phone, the vehicle would show up, the passenger would get in, the vehicle would take the person to wherever they wanted to go. And the whole time the person getting a ride from the vehicle would not have to be licensed to operate it. The question about license to operate really comes to the point of who can push the go button. And again, the example used is the mechanic who would have to have a CDL in order to move one of these things around the yard. Just to push the button would have to be therefore have a CDL license. The other friction point in this area is from a safety perspective, YDOT felt that the vehicle should notify a human driver if there's a human driver station that the autonomous vehicle system was disengaged, like it's currently done on a cruise control or an autopilot in an aircraft, simply for safety purposes. And the industry stakeholders, again, thought that got into design and preferred that language not be included. From our perspective, though, and why not, that was a safety, that a human driver should know if the system's engaged or not when they're sitting in the vehicle. 3121-110, the industry stakeholders just are against any discussion of testing. YDOT considered, we tried to make the language again to appeal to the holistic and the safety considerations that we were given. We tried to make it as benign as possible. The staff even discussed removing it, however, and then just keeping it for rules and regs. However, then we got to the point where if it's not authorized in the bill and we put it in rules and regs, someone may cry foul because the bill didn't authorize us to have a process for testing. Some industry folks would prefer it to, instead of be a temporary operating permit for testing or development, more of a notification. Again, the staff recommends that it be more than notification, that it actually be a special use permit. We equated this to a safety issue along the lines with how we currently handle oversized or overweight movements. So we know that they're happening and we know when they're happening. And then B, we took in consideration the public. And really what we're looking at here is comfort. I read occasional stories and or surveys about public comfort with AVs, and I'm not familiar with any specifically done in Wyoming, but generally, when these surveys come out, 40% of the public's pretty comfortable with AVs, 40%'s on the fence, and 20% not so much. It's something that they don't trust. So from our perspective, we felt it necessary to put it in the bill. You'll notice we use the word may develop procedures instead of shall, which authorizes the department what we feel is the correct flexibility to address the testing and safety concerns, but hopefully not be too restrictive for industry testing efforts in the state. And then finally, 3121-111. And I don't really have anything to highlight there other than some industry folks wanted language less restrictive using the terms shall instead of may. The department's recommendation is careful where we use those terms shall and may. Where we recommend shall, that's where we're trying to be less restrictive but have the option in case it's necessary. As the technology evolves and adapts, we felt it was better to adjust rules and regulations than the statute. Where we use the term shall, we felt it was necessary to prevent that if we did put a rule and reg in, that someone would object to it because the bill didn't specify we could. So where you see shall in here and where you see may in here with regards to what the department is supposed to do, that was careful consideration on our side. And we would recommend that the shall and the may stay where they are.
Mr. Co-Chair.
Yeah, Chairman Von Flaters.
So Jesse Kirchmeyer, Mr. Kirchmeyer, on 3121-110, if the previous chapter are met, or however they want to say that, do you need the following, or do you need the testing aspect of it to be done? So if the previous chapters are met, could it be forgiven that they don't issue a temporary operating permit?
Mr. Chairman, Mr. Co-Chair, yes, Mr. Co-Chair, I believe that is correct. And we were trying to be careful here. And the reason we were trying to be careful is, one, we were told to provide a holistic bill. So we felt we had to at least attempt to address the testing issue. And we heard industry concerns that if testing is in the bill, it could delay company efforts to come into Wyoming and conduct it. Because then they would want to wait and see what the department rules and regs said about how we were going to handle it. On the other end, if we decided that we put testing or a notification or a special permit in rules and regs, when we publish those rules and regs, someone can come back and say, well, you weren't authorized in the statute to have a testing permit procedure. So this is not, you can't do it. So that's where we're trying to be careful and walk that fine line between safety, addressing everything, and making sure that we have the flexibility to adapt as this technology develops, sir.
So
hang on a second.
Mr. Chairman.
Go ahead, Chairman.
So, Mr. Kirchmeyer, if they meet everything else, you still want them to get a testing permit, or they can forgo the testing permit if they meet all the above?
Mr. Chairman, Mr. Co-Chair, from the perspective of WYDOT and how we viewed this, if everything else is met, I think our operating assumption is the vehicle's fully licensed or fully developed and fully complete. However, there may be cases where a vehicle isn't fully licensed, and I know I'm not using probably the correct terms in how the feds authorize these things. And an example is environmental testing of a truck on I-80 in the middle of a winter, right? That is a unique thing to Wyoming, and there may be a trucking company that needs to run a test where they don't know yet that their vehicle can do everything it's supposed to. So they're going to want to test that capability. And in that case, the vehicle isn't fully licensed to operate. And so that's where we felt that allowing the department to have a procedure to get to be involved in that process, and knowing about that process so we can communicate it to the public, have law enforcement available if necessary, and anything else that might come as a result of that. Again, that's why we wanted this paragraph in here. And of course, we felt it was necessary to public safety, sir.
Heather, did you have something you wanted to come in here on?
Mr. Chairman, I just wanted to draw the parallel that this particular section about temporary operating permits more or less mirrors the WYDOT's ability to issue special temporary operating permits in the commercial vehicles section for vehicles on the highways of the state consisting of more than 3 single units. So it's draw the and that's at 31-18-807. The attempt was to give them broad authority and not to allow. I think the idea was to allow testing, not to limit it. So it just was, and it was mirroring that other section. If anyone was looking at that.
Representative McGuire.
Thank you, Mr. Chairman. So I'm curious, what is the limit of liability? So let's say that this stakeholder is testing a vehicle in Wyoming, and it's a day like today where it was crazy slick this morning, and their autonomous vehicle goes out of control, wipes out a family that's taking kids to school. What's the limit of liability? What is their responsibility to the residents of the state of Wyoming while they're quote unquote testing this vehicle?
Mr. Chair, Mr. Co-Chair, Representative McGuire and Heather, I'm sure I'm fine if you break in. From our understanding, sir, we pointed back to the existing liability limits, and that is 1 million and 5 million, I believe. Not noted in this bill, but it points back to existing statutes, and I believe that's covered in 3121-104. And it actually is specified primary automobile liability limits of 1 million in A subparagraph I. And then also uninsured motorist coverage is also addressed and points back to statute 3110-101. And this was our effort to try to, as much as possible, again, trying to be less restrictive, more permissive, treat AVs, despite their unique characteristics in some cases, as much as possible like other vehicles.
Okay.
Follow up to that question, Mr. Chairman.
Yeah, go ahead.
So when they're testing the vehicles, they're going to be fully licensed and insured. Is that what we're saying? They're not just putting them out there without license, temporary permits and that kind of thing?
Mr. Chair, Senator Anson, I think your comment gets to the heart of why we recommend the special operating permit paragraph in there in the first place. If they're testing, we're making the assumption the vehicles aren't fully approved by federal standards, and they're going to be testing something the vehicle is, they're still working on designing the vehicle to be capable of doing. I'm going to make the assumption based upon the review of the WYDOT staff and our Attorney General assistance that the way we recommended the wording covers testing liability limits appropriately. And I am not a legal expert, and I would have to defer to someone else that if it does not do that, how to fix that. But you're highlighting why we recommend that special use paragraph for that very reason, to make sure that all those other things are in place before a vehicle that hasn't been fully approved is put out on our roadway system, interacting with our public while that development is going on.
Okay, any other questions? So you're finished, Mr. Kirchmeier, with your presentation, correct?
Mr. Chairman, I am. Thank you for your time.
Thank you. Do we have some public testimony, Mary Beth?
Mr. Chairman, I see that Senator Rothfuss just entered the meeting, so we might want to go to him.
All right, so we're ready for the digital innovative technology people. Senator Rothfuss, welcome to our meeting. Go ahead when you're ready.
Thank you, Mr. Chairman. I appreciate the opportunity to speak. And Mr. Chairman, I just wanted to chime in support of the legislation of the work that was done by the working group, this committee, and we had an opportunity to weigh in and take public testimony as well to try and understand the key issues with regard to the autonomous vehicles. And our select committee is very supportive of it, but in finding out that your committee was working on it, we wanted to make sure that we left you the opportunity to lead on it. And we're happy to help out, serve in any way that we can, and support your efforts. But it seems like it's in good shape. We saw the last bill draft and had an opportunity to talk through it, the co-chairman and I, and appreciate the work that you've done on it. So unless there's any questions, I'd just say that I like the direction it's going. I saw some of the suggestions that the department wanted to have in place for some additional certainty, and think that that's all prudent as well. So it's an excellent first step for us. Thank you, Mr. Chairman.
Okay, thank you. Any questions? Not seeing any. Do we also have Representative Olson here? Mary Beth.
Mr. Chairman, he may appear shortly, and if he does, I will admit him. But currently, I think he did have another meeting that he was attending.
All right. So Director Reiner, I think we'll bring you in here, and you can talk.
Yeah, thank you, Mr. Chairman. I would simply say, hey, the future is coming at us. The future has autonomous vehicles. They're here. I think I appreciate the leadership of the legislature and looking forward and posturing ourselves to safely accommodate technology and on our roadways. And I appreciate the work of Mr. Kirkmeyer and the team, and fully support this legislation, and will support as we go forward. So I think it's important for us to pursue and to get in place. Thank you, Mr. Chairman.
Okay. Any questions for the director?
Yes, Mr. Chairman.
Yes, go ahead, Senator.
Thank you, Mr. Chairman. At one of our last meetings, we talked about possibility of trucks on I-80 that were testing the autonomous vehicles, and they had engineers on board and that kind of things. I was recently on I-80 and I saw a truck with blacked out windshield and blacked out sides with the Nova on the trailer. Is that one of those test vehicles that they were running on I-80?
Mr. Chairman, Senator Anderson, you know, I cannot speak to that. If there's somebody else on board here who can, I'd appreciate some help answering that question.
Mr. Chair, Senator Anderson, I'm not aware of any company currently that has requested through department or through the Highway Patrol to conduct any testing of AV technology. The company you referred to is not a member of our working group. We do have a trucking representative member of our working group. So I'm also not familiar with that.
Representative Blake.
Thank you, Mr. Chairman. Director Reiner, do you see the department really digging down deep and looking at conditions that are exclusive probably to Wyoming, high winds, super slick roads, road closures, chain laws in effect? Do you think, I'm sure it will be looked at, but can you tell me, is that what the department is going to be looking at when they review and make their rules and regulations, restricting certain conditions that they can't drive?
Mr. Chairman, Representative Blake, I certainly think that's our responsibility, is to determine when it's safe for each type of vehicle to be on the road. And I would certainly see that in rules and regs. I think down the road, you know, the same rules will apply, but there's a lot of discussion to be had there. And that's part of the rules and regs development, and the responsibility is to make sure we keep these roads safe for all vehicles.
Representative McGuire is there, sir.
Thank you,
Yeah,
The last time that
Go ahead.
we looked at this, one of my questions was, and it still remains a question for me, what about our local law enforcement? So you've got a sheriff's deputy in Medicine Bow, you've got an autonomous vehicle, maybe it's lost its way, maybe it's off by 10 feet, maybe it's an ongoing lane, and it's moving forward. What does that local law enforcement person do? He can't get in the vehicle, he can't find a number, he doesn't know who the dispatcher is. How does that local law enforcement official react? And the second part of that question is, what about, let's say that that local law enforcement official has got a problem with that one vehicle, and the same company has 5 or 6 vehicles around the state that are all going haywire at the same time. How does YDOT react to that? Who has got the on-off switch? Who is able to go in there and say, you know, if you don't have a conductor in that truck, who's got the ability to shut it down? And I think that is a question that just has to be addressed, because everybody trusts in technology. But at some point, when there's a problem and it's snowing and there's nobody around and you got one single sheriff's deputy, what does he do? Start shooting out tires? I mean, give me a solution here that we can take back and say to the people, we're protecting you. This, if everything goes wrong, this is the out. This is the off switch. Thank you, Mr. Director.
Yeah, Mr. Chairman, Representative McGuire, you know, you always ask some intriguing questions, and that one certainly I can just imagine the day when that goes down, because it'll be blowing and it'll be cold, and you're going to have other cars that are wrecked, but what I know is that we'll work through that in rules and regs, that has to be addressed. Otherwise, it's not safe to put those vehicles on the road. And as terms of the specific on-off switch right now, if Colonel Haller or Mr. Kirkmeyer has an answer that you know can address the specific question of Representative McGuire, let's answer it. Otherwise, what I'd say is, hey, listen, that's part of our responsibility in rules and regs to ensure that we know what the answer to that is before we turn these vehicles loose. Yeah, go ahead.
How, yeah, I've not meant to exclude you, but I just found you on my screen. So if you'd like to join into this conversation, and then we've got some other questions here.
Thank you, Mr. Chairman. Kevin Haller with the Highway Patrol. Mr. Chairman, Representative McGuire, that is a very good question. I think that is something that is going to look us in the face down the road. We are learning as we work our way through this on the law enforcement side of the house that for example, Tesla, one of the leaders in this field, they actually have guides that they provide to law enforcement. There is also information in those for dispatch centers that are actually operating those vehicles that law enforcement dispatch could contact to deactivate or shut down those vehicles. But your question to the immediacy is a concern, and it is a safety concern, and that's why I think that that consideration to move slowly and have driver assisted drivers in the vehicles as we begin. And that's why the testing becomes important in the statute and the rules and regulations where that information can be captured. This is also going to be a big training issue. And that's inclusive of law enforcement, fire department, towers, on how to safely investigate these vehicles. And respond. The batteries, for example, are very high voltage, and having the understanding of how to safely disengage those batteries with the understanding that they can still operate up to 10 minutes later because of the voltage and the charge that is going through the system. So there's a bunch of issues that we continue to have to work out.
Okay, Senator Steinmetz.
Thank you, Mr. Chairman. I just have some questions and I don't know if they can be answered, but I think a lot of us were on this committee a few years ago when we saw the two-man crew bill that with regard to railroad safety, and that we were seeing crashes and loss of jobs because the railroad system has become automated and is utilizing technology similar to this already. And so with that in mind, I just wonder if that provides us any guidance, or if you've thought about what the railroads are going through, what has been before this committee with those issues, and then how much more dangerous is it for a fully automated vehicle without tracks to guide it, might be for the state of Wyoming. And if we truly want to be a test state, I missed the last time you had a discussion on this topic, so I might be covering ground you've already gone through, but what are the advantages to us being a test state, or to adopting this legislation as opposed to maybe letting someone else be the guinea pig here, and we come in when this technology is a little more sure. So if you could answer those questions and give me a little guidance, I'd sure appreciate it.
Mr. Chairman.
Okay. Yes.
I think he said yes. I'm not sure, really. Senator Steinmetz, I will say that Yellowstone Park is going to use this facility or use this type of equipment this summer. And Yellowstone Park resides in Wyoming. And so we need to get this legislation out, at least a beginning of it, so they can do it, because the companies that want to test or experiment in this city or in this state do not want, they don't want any regulations, of course, but we're going to try to put these regulations so we can get those people to come to us and create an industry, we hope, at some point, economic development around the driverless cars is what we're trying to do.
Does that answer your question, Senator Steinmetz?
Mr. Chairman, I also think Mr. Kirkmeyer was wanting to jump in. I'll jump in also, but I think he's got probably can add a few comments to that if you're all right with that.
Yes, I am. Go ahead, sir.
Yeah, Mr. Chairman and Senator Steinmetz, I think that there's roughly in the high 20s of states that have either legislation or executive orders that kind of govern the state's approach to autonomous vehicles. From the industry perspective, what I'm hearing is they want to know what the rule book is in the state in order to even consider going there and testing. And if they don't know what the rule book is, it's really hard for them to determine whether or not they should go there. So we wanted to kind of give them a rule book. They may not agree with all of our rules, but at least they know the rules if they come into the state. The second thing is there are a lot of states that just start with a testing legislation. And the feedback from the industry is that's overly restrictive, and that hinders what they view as what they need to develop their product. So we tried to walk that fine line between establishing that rule outline or that framework that we can then clarify in rules and regulations and address all components from testing through eventual full deployment. And you are correct. There will be a day where, the industry says that these vehicles, when they're fully developed, will be safer than human drivers because they won't make human driver errors.
Mr. Chairman.
Yes, go ahead. Representative Squire.
My question would be, so what are these industry stakeholders willing to invest back into the state of Wyoming? So, for example, they want to come in and let's use the Yellowstone example. there will be fewer jobs for Wyoming people. Presumably their control center is not going to be in Wyoming. So we're going to have fewer jobs. Presumably these vehicles will be electric. So we're not going to get any kind of fuel tax or anything like that. We'll get a small amount of registration, which hopefully they will license their vehicle. That's another pet peeve of mine, is companies that come in and don't license their vehicles in the state of Wyoming, because we should have a statewide mandate. But anyway, that's something for another day too. But maybe they come in for the season, they don't even license their vehicle in the state of Wyoming. What's the benefit for the state? Where's the investment for the state? WYDOT is going to spend a lot of time and money preparing for these industry stakeholders. Where's the quid pro quo? Thank you, Mr. Chairman.
Who'd like to answer?
Mr. Chairman, Representative McGuire, what I would say, sir, from WYDOT's perspective, our role, our task was to provide the framework to safely test and integrate the vehicles. As far as enticing, encouraging autonomous vehicles to come to the state, I'm not really addressing that in the working group because that's not our role. However, I will say you are correct. In every instance where I have talked to other DOTs, if AVs test in their area, it costs them money. The DOT. Now, I'm not making a value judgment on whether the jobs or the industry created in the state brings in the revenue to offset what the DOT spends. I don't have that information, but it costs the DOT money if a company wants to come in to Wyoming and test. What I will say is our current stakeholders, which include a couple of OEMs and includes a couple of the industry representative groups. I'm not aware, other than the Park Service test that's going to happen in Yellowstone this summer, which is really just a 3 or 4 month test, and they'll run a shuttle service around the park area. Though we've already made arrangements for those vehicles to be licensed in Wyoming. But I'm not aware of any company wanting right now to come to Wyoming and test. And again, my perception is, and I'm sure an industry rep will correct me in conversations with you later, but my perception is until we have a legal framework of some sort, they're going to wait and see. They're not going to let us know they want to come. They want some kind of legal framework so they know what they have to deal with if they decide to come to Wyoming and test.
Senator Rothfuss, did you have something you wanted to bring into this conversation?
Yes, thank you, Chairman Eklund. I did. I just wanted to address and echo some of what we just heard. But when contemplating this, I think it's important to realize that there isn't industry out there saying, hey, we need to pass these laws because we want, if you do, we'll come to Wyoming. On our select committee, when we've considered this, we were trying to be proactive, honestly, and recognizing that Wyoming is behind 30-ish other states, and that we're playing catch up, if anything. But recognizing that there are a lot of dollars ahead in this space of autonomous vehicles. It's hard to say exactly where those dollars will be and how they'll be and who will get them. But as our select committee has looked at kind of the horizon of technologies and where the big plays will be and where big opportunity is, the autonomous vehicle space is just one of those spaces. Vehicles will be primarily autonomous in a few decades, and that's just the way things are going to be. So do we kind of want to be kicking and screaming our way into it, or do we want to try and find ways to lead and engage? And on the select committee, we really were trying to find ways to engage. And so we brought industry in and we asked them questions about, do you want to come to Wyoming? And they said what we heard Mr. Kirkmeyer say, basically, which is you don't have you don't have any laws, you don't have any regulations. We're not even really looking at you at this point in time. You're not trying to lead. So one thing that we realized we certainly needed was a piece of legislation like this that would create that foundation. Until we have that, it's really difficult to explore some of the concepts that Representative McGuire is talking about, which is how do we come out ahead? And we know that's a challenge for us all across the board, as Representative McGuire did point out. We don't tax things, we don't have revenue, and things do tend to cost us more than they earn us because of our revenue structure. But these are problems that kind of come together and become a confluence as we consider this. But one other point, Mr. Chairman, that I did want to address is when you look at the long-term vision and you start contemplating safety and you start contemplating what's in it for the people of Wyoming, it isn't just that the single car makes a better decision based on its individual circumstances. The future of this technology of autonomous vehicles is that the cars are all communicating with one another about the circumstances around them. And so when you have an accident 2 miles up the road, every car on that highway knows exactly where it is, exactly what's happening, exactly the circumstances, and they all begin to respond, and they will interact in a way that provides additional safety. So, even if we don't end up being, Mr. Chairman, a big player in this, and we don't benefit from testing or development or manufacturing or programming or anything else in the state of Wyoming, all things that we would love to participate in, but even if we don't, the people of Wyoming will benefit a lot from the safety in the long run. And it's not just for our people, it's for those trucks that are going down I-80, when those trucks aren't making bad choices, and when they don't jackknife when it's -40 out in a blizzard because they're not experienced ice drivers, when they have the good sense because the AI tells them to, that 20 miles per hour is probably even too much under those circumstances. It's going to be a real benefit for the folks in Wyoming, and without a framework in place, it seems like we're holding things back for Wyoming. So the Select Committee is very interested in seeing this move forward because we do want to find some economic development activities. But I think just from a general standpoint of what's in it for Wyoming, it's a better long-term vision, I think, for the folks in Wyoming to be able to benefit from this technology. If we're participants at a minimum, and if we can be innovators and leaders, that's even better. Thank you, Mr. Chairman. And I see my co-chairman's here, and he might want to weigh in. I see that he just showed up. Thank you, Mr. Chairman.
So as soon as Representative Olson is finished, we're going to take a break for probably half an hour. And it's I think it's a necessary one. We have to get a YouTube feed set up somehow, I think. So Representative Olson, you'll be the last speaker, and then we'll break for half hour. Go ahead.
Thanks, Mr. Chairman. I've prepared 2 hours worth of remarks that stand between you and that break. So I want to, because I apologize for being late to the game, Mr. Chairman. I was on a panel, and I was trying to get off of that as quickly as I could so I could get here. I want to echo my co-chairman's support for the legislation and thank the working group for all of their hard work on working through the issues. It's got some difficult parts to it, and it's in a lot of respects, it's very futuristic in thinking. And so I want to commend the working group for being progressive in that sense and working that issue forward. What I would say to the committee is, our select committee is very, very interested in moving the issue forward. Each of you have a decision to make on every bill that you have as to what is the benefits, what is the drawbacks. I would urge that as you consider this legislation, that you maybe don't come at it from a single lens of what is the revenue for the state of Wyoming. I think that's a relevant question in everything we do, but it's not the only question that we should consider. I think we should consider things like public safety and whether this has the possibility and the chance to revolutionize public safety. I personally think it does. I think it does on the I-80 corridor, where that issue has plagued Wyoming forever. So I think it has tremendous potential to change safety amongst not just commercial, but passenger vehicles as well. So I think you should think about all that. I think you should think about the reality that 38 states, which include the District of Columbia, have some type of autonomous vehicle legislation or executive orders in place. So this really is, the first step is really just getting Wyoming caught up with where the country's already heading. I think it is only the beginning. I think the next step is to make Wyoming a leader and to revolutionize it. The question of how hungry is industry for it is certainly a question, but it's not the only driver. I think that we have opportunities sometimes as lawmakers to lead the charge and to bring about the excitement about moving something forward, to get industry excited, to bring industry to the table. And so it does have economic development flavors to it, but we can play a part in that. This morning, I was looking at a map of Wyoming. I was curious on how many Tesla charging stations there are in Wyoming and what the routes would look like if you were to use those. So I was looking this up, and there's surprisingly, they actually have charging stations, 2 in Cheyenne, and they have 1 along the I-80 corridor in every major town. And then moving north, they actually have quite a few as well. So I was surprised to see that there were more than 6, for example. And my point with this is I read a few months ago that Tesla was working really hard on producing an autonomous electric vehicle for under $25,000. And I think that's a pretty interesting concept to think about, because electric vehicles are priced really high. And so they price out most of Americans. If you were to have a vehicle in the price point of what most Americans can afford, it changes how the public interacts with that industry. Of course, you have to have those charging ports across the country and the states to even make it make sense. My point with all that is that, if you go out and you look at GMC or Ford, what you're going to see is that Ford is producing an all-electric Mustang next year, and you're going to see that GMC is producing an all-electric Hummer next year. And I think what you would see in the next 5 years is those are going to be autonomous. So it's not a question of what this does for the state, or what revenue there is for the state. I think it's a reality of that it's the future. And Wyoming has an opportunity to, 1, get caught up, and 2, become a leader here, so that we have the opportunity to have things like manufacturing down along the I-80 corridor, so that we have opportunity for certain charging stations or whatever it may be. If we're late to the ball game, we just don't have those opportunities. So I think with that, I'll leave the committee to further contemplate the bill, but those are my thoughts on it, Mr. Chairman.
Thank you, Representative. So committee, we're going to break until 1:45. I think half an hour. I need a show of hands. Everybody okay with just a half-hour break? Speak up if Representative Obermuller, you're good? Or you got something to say? You're muted. Oh, okay. All right. It looks like everybody's okay with a half an hour. We'll see at 1:45.
Gotcha.
Okay. Bye.